May I pray?
Yes.
May I pray for listing in the next week, any convenience day?
No. Because you have to mention it before this court number 4, bench 4 and bench 5, not here.
Oblige, sir.
May it please your lordship. With the consent of other side, I beg to mention item number 19. Lordship, the engaged counsel is in high fever, so the matter may be adjourned for the day, lordship. On behalf of A. Hassan. SRN Nasir. I'm
Who?
not. No, sir.
Fever.
A. Hassan.
The request of the learned counsel for the petitioner. The matter stands adjourned to be lifted 28/2026.
Deeply obliged, lordship.
May please your lordship. Lordship, I filed 2 writ petitions. It came up before Honorable Court number 5 yesterday. Your lordship, Honorable Court passed an order to list before any other court beside the court number Honorable Court number 5. Your lordship, I pray your lordship it takes up the matter. Your lordship. To motion your lordship today. Your lordship. Tomorrow, lordship.
First, item 1.
Lordship. Today the matter is fixed for issues, framing of issues, your lordship. We were directed to complete the formalities of filing affidavit on denial, admission and denial. That is being filed today itself, your lordship. And for the other parties, I have received a copy now.
Anyways, my question is, why don't both of you parties, you have some of your patent, it's a case of patent?
Please, your
Patent has already expired.
Lordship.
You have a counterclaim.
please, your
Why are both parties not going for mediation?
An attempt can be made, your lordship. That
can be.
Huh?
that
We
can
can
be
go
done,
for
your
mediation.
lordship. We can sit for a
Mediation, because you see, one of the parties have already, you have already finished off.
lordship.
You had made certain claims out there. I think it is better for mediation. As both the parties have duly agreed to. As the parties to the present proceedings have agreed to. This court refers the instance dispute for mediation. The registry shall place the matter before the mediator, before a nominated mediator. Is this matter again on 16th of September? Today is what? 16, na? 16. Let us have it on 22nd of September. Is this matter on 22nd of September for a report? It is further observed that the report of the mediator. It is further observed that in the circumstance, the parties have amicably resolved the dispute through mediation. The matter be placed before this court forthwith so that appropriate directions can be passed.
Deeply.
Item 2.
Well, on my implement application, I don't know to press it because we have gone before the appropriate forum, before Mala project for Deputy Commissioner for claim. We file a suit also for Meghalaya. So I don't know to press at this moment. We have taken the recourse of it. Your lordship didn't enter in the implement application. Your lordship has kept it side.
Just 1 minute. Let me
Yes.
see what is the matter about. Yes, Mr. Saivela, what is your case?
Yes, my lord, that you want to withdraw, my lord, that.
Okay, what is your case?
My case, my lord, 13(3), your lordship's order, pass an order directing the circle of sale, my lord, because it is a land acquisition matter, my lord. They have occupied the land.
Yes. What do you have to say, Mr. Andy?
After this lordship orders, I already been communicated, I have not received any instruction. My instruction, my lord, it was sent on to the 2021. So they said that, my lord, the survey was made, my lord, it was sent to the agriculture department regarding, my lord, the Jirat. My lord, the value of the, my lord, the Jirat plot.
So you have not acquired.
Lordship,
Who is to provide the instructions?
my lord, this is, it was,
We have it tomorrow.
Polasbari revenue, sir.
Have it tomorrow. And see the face of the circle officer, Polasbury Revenue Circle, as he is not providing instruction. Let me, what is all these things? Now there is a dispute. Who is the owner?
My lord,
I claim that I am the owner of the land.
but
And you also claim that you are the owner.
my lord, but
Now, the question as to who is the owner, when it is in dispute, can Assam Mala scheme be at all taken into consideration?
Yes.
Assam Mala scheme comes on the basis of that there is an agreement. There has to be an agreement.
Correct.
To the effect that we are agreeing with each other that this is the rate, we shall not later on file a reference proceedings. This is the agreement
my lord,
and
everything
the
is-
rate is fixed.
Yes. Everything is in my favor, my lord, because all the revenue records, everything, my lord, because here they have said that a sale deed has been executed in Meghalaya, unregistered sale deed in favor of the petitioner who filed this,
No, understood.
my lord.
So therefore,
Yes.
by way of, if there is a dispute as regards ownership,
It's not a dispute at all, my lord.
Yes, we file a suit also.
Suit,
Also
that
a
is
suit
state.
file, they appear
Suit
in the
state.
suit.
Suit state.
I didn't press, your lordship must keep aside. I knew, my lord, where my remedy lies, my lord.
no, when there is a dispute as regards the ownership,
My lord.
can at all the Assam Mala project be enforced? My
No,
question is,
First thing, my lord, they have not fixed anything, my lord. Amount should be fixed first, my lord.
therefore,
Ah.
when there is a dispute between both parties, then I don't think they can go for Assam Mala.
There is a dispute, my lord, cannot be go, my lord, because the agreement should be made the main lordships.
It is only when it is a case of undisputed things. In fact, I have, you were there yesterday.
Yesterday, lordship, yeah.
There was one matter which I have fixed it on 5th, 21st of August or 5th of August. What is the name? Huh?
ADC, Dharam was there.
No. Not it. I have asked the additional chief secretary, revenue, to file an affidavit as to what steps can be taken. Can Assam Mala at all happen? When 21/8? You have to file the affidavit by 18/8, if I'm not wrong. Yes.
My lord, normally there is an agreement. So you cannot go for agreement, you are binding the agreement on the basis. So there is no agreement.
In fact, Mr. Das, the issue which I took up yesterday in that matter is that the Assam Mala presupposes that he's the owner. No. It presupposes that he is the owner. One. There is an agreement. Once there is a dispute between both the parties, as per the Land Acquisition Act of 2013 or 1894, or even in the case of 1964, it is the deputy commissioner or these people cannot adjudicate this aspect. It has to be only adjudicated by the reference court.
Right.
There's no quarrel with that. Then in that regard, at all, as to whether can there be an acquisition under the Assam Mala project?
That's the issue.
Because there, what has happened, they have entered into an agreement with some person.
Okay.
Who is the respondent. And the petitioner is also claims to be the owner. Then can there be at all an acquisition?
They have
Yeah.
already taken the, my lord, land.
Huh?
They have already taken the land.
So they have to acquire then.
Yes, they have to, my lord, because they have to fix the compensation, my lord. They, this, my lord, that all the photographs are there, they have already taken.
No affidavit has been filed.
No, my lord,
2021 matter.
yes.
55 bigas, and 60 all required.
Why no affidavit has been filed? The present petition has been filed in the year 2021. And the notice was issued as far back as on 22/4/2021. Service of notice was duly effected upon the learned Government Council. However, till date, no affidavit has been filed either by the PWD authorities nor or by the district administration. In fact, on 13/3/2026, this court sought instructions from the circle officer, Polaspally Revenue Circle. However, today Mr. J. Hendrick, the learned junior government advocate, submits that in spite of information being provided, and in spite of instructions being sought for, the circle officer, Polaspally Revenue Circle, have failed to provide the necessary instructions. The present case is a case whereby it is alleged by the petitioner that under the aegis of aegis of the Assam Mala scheme, the land of the petitioner have been already taken over. The possession of the land of the petitioner had already been taken over. And there has been no agreement entered into. And neither any agreement has been entered into, nor any payment of compensation has been made. This will come under whom? Who does all these things? The Assam Mala project, who does? Considering the above, as the present petition cannot be proceeded with, in absence of the appropriate instructions, and the instructions have not been provided, by the district administration of Kamrup Amingao of Kamrup, this court, for the end of justice, directs the personal appearance of the district commissioner, Kamrup Rural, on 27th of July 2026 at 10:30 a.m., on which date he shall duly provide the instructions under what authority the land of the petitioner have been taken, the possession of the land of the petitioner have been taken. Mr. J. Hendrick, the learned counsel, junior government advocate, shall provide a video conferencing link to the deputy commissioner, district commissioner, Kamrup Rural, which would aid in, which would, so that the said district commissioner, Kamrup Rural, is in a position to appear through the video conferencing link. List accordingly.
I am allowed 800 maybe dispose of my land.
Mr. So-and-so, the learned senior counsel, assisted by, you are not assisted by anybody.
There is no seat. There is no seat to stand. That's what seat two.
So-and-so,
Yeah.
you are standing, she should also stand. So-and-so, assisted by so-and-so, submits that he doesn't want, the petitioner, the applicant does not want to press the instant application. Accordingly, the application stands closed on withdrawal.
I communicated the draft order. It was communicated on 19th.
It's okay. I'll take it. You remind me on next date. Then I will take it up with this district commissioner.
For admission item 3,
Yes,
Your
sir.
lordship. In
Three
this,
days.
in this matter, lordship, on 21/11/2013, the respondent number 3 floated an advertisement inviting application from amongst the upper division assistant for appointment of the post of head assistant as per Rule 6(1) of the Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987, lordship. Petitioner and one Kanakchandra Soikia was applied for the post. And on 22/1/2014, Kanakchandra Soikia was appointed as a head assistant, lordship. Petitioner challenged the order of the appointment, and during the pendency of the writ petition, Kanakchandra Soikia was retired. After that, on 25/2/2015, respondent number 4 promoted as a supervisory assistant as per Rule 6(2), lordship. That order was challenged by filing a writ petition, and writ petition was dismissed, lordship. For this reason, lower and average grading given in her annual confidential report, lordship. After that, petitioner filed a writ appeal, lordship, and writ appeal was disposed on 27/2/2019. And Honorable Division Bench directed to reconsider the case of the petitioner. After that, petitioner submitted representation before this authority. And on 9/7/2022, impugn order passed by the respondent number 3 denying the consequent beneficial financial benefits to the petitioner, lordship. And the reason for denying the apply for the principle of seniority cum marriage, wrongly apply for the principal, lordship.
Where is the division bench judgment?
Page 28, lordship. Relevant page 28, lordship. Last part, lordship. As per rule, lordship, there is not fixed benchmark, lordship.
Yes.
Look, in this case, initially in the year 2015, the petitioner was found to be not fit for promotion on two counts. First, 3 ACRs, in 3 years ACR, she was graded as average.
No,
And
I'm not on that. Is seniority come merit?
well, I'll come to that, my lord.
You come to that only.
No.
Yes.
Because this consideration was made, last page of the writ petition was pursuant to the direction of the Honorable Division Bench. So, Honorable Division Bench decided that you don't consider the penalty aspect. You decided whatever is there in the
Understood.
ACR.
It is also mentioned in the.
This
division
last
bench-
paragraph, I
No,
think,
no, the division bench further mentions not to disturb that
Yes.
person concerned, the respondent number 4, not to disturb him. But the question is whether she should have get some financial benefit.
benefit or not.
Now my question is, you have now again while deciding it.
So this last paragraph of page 32 in
Oh.
my humble submission, my lord,
Yes.
it is unnecessary. It was because after the,
8,
what I'm
paragraph 8.
paragraph 8, because after the honorable division bench decision that don't touch the private respondent, you only assess her merit. So para 7, I think in my respectful submission it is given, because inter se comparison of with respondent number 4 therein was not absolutely required. So para 7 is relevant because here they have said that average grading was there.
No, first of all, for the purpose of seniority come merit, where is the benchmark? Minimum benchmark fixing.
No,
See,
Lordship
when
is
you
correct.
have to consider on the basis of that, where is the minimum benchmark you have fixed?
No, lordship is correct.
This is
but
purely going on the basis of merit.
true, my lord.
Then
But after the honorable division bench decision, there is no requirement of holding inter se merit.
obviously there was no requirement, but if you have taken it also,
Because
then also you could not have without fixing the minimum benchmark.
the lordships kindly see the division bench's order once
I've
again.
seen it.
In the instant case as noticed, the reason put forth was also that the ACRs of the appellant for the year 2009 to 13 had certain adverse entries. In that view, the comparative assessment of the same along with ACR of respondent number 4 herein is a matter which has to be taken note by the DPC. It was
Right.
said by the honorable
So
division bench.
there has to be a comparative merit.
Comparative assessment has to be
So
done.
therefore, the comparative merit has to be taken with the petitioner with the respondent number 4. Now, the division bench said that we are not going to disturb his promotion.
That observation of the honorable division bench is important, my lord.
Yeah, but
Yes.
then also there has to be a comparative merit. Comparative assessment has to be made. But now, once the comparative assessment has been made, unless you fix the minimum benchmark, how can you say that he is average? He has got one very good and the other has others to be here, and as such, he is not entitled. Unless you say that if he has this minimum marks, if he does not, this is the marks on which we are to look into it, because there's a word out there. In that view of the matter, a comparative assessment of the same along with the ACRs of the AR herein is a matter which has to be taken note of by the DPC by excluding the so-and-so. Meaning thereby, it has to be taken vis-a-vis the respondent number 4. We don't disturb the respondent number 4. But the petitioner was entitled, and as such, the petitioner should be granted the
Notional benefit. My lord, petitioner's entitlement, in my respectful submission, will be determined by the DPC on the basis of remarks in the ACR.
Understood.
As of now. Because since honorable division bench has decided not to disturb, so inter se compare, because he is already served and he has retired. So this Saidul Islam.
So therefore, so we are not going to disturb Saidul Islam, or the petitioner has also retired.
Yes.
The DPC should have decided after honorable division bench order whether taking into account those ACRs, 5 years ACR, she is suitable for promotion or not. That should have been the criteria. Because the law says if there is comparative assessment, it goes to the merit. So that's why the only exercise that should have been done, whether this 5 years ACR, she gets the promotion or not, notionally. That should have been the decision of the DPC, my lord.
Now what
That is why I am
how
saying
many years the petitioner keep on suffer?
my
6,
He has already retired in 2017.
5 years,
Lordship.
my submission is that
2015, Lordship.
15 you have retired.
Yes, Lordship.
my submission is that, my lord, they never attempted to expunge those adverse remarks. No application
No,
was.
no, my question is, forget about that. They have not considered that there are adverse remarks in this order.
No, no.
Where have they mentioned in this page
Complete-
33?
Look, it's a settled position that average grading cannot lead to promotion. Average grading in the ACR cannot lead to promotion.
She had got a good also, very good also.
Good.
Only
Not
Lordship
5 years.
average grading in the year of 2009.
Then he
Look,
got good
this-
on 3 occasions, very
He got
good one occasion,
Yes, Lordship.
only average once. Then,
But my record says,
we are not going to go by your records when you have not filed your affidavit.
Fine.
And more particularly when in paragraph
Fine.
number 7,
Fine.
this is
Fine.
mentioned.
if even if a single year there is a grading of average, the DPC has got the power to assess the merit of the person to give him promotion or not. So initially also, this was the criteria. Two things. First, there were adverse remark in the ACR and penalty. Honorable Division Bench will not taken away the penalty aspect and directed that you hold a review DPC considering the ACR. When the average remark was there in the ACR,
The DPC has not done that. Did not consider any adverse remarks.
no, it's average only once
Where,
in
where,
the year
where?
to para 7, madam.
But that I've looked into, where
Yes.
they have mentioned about the adverse entries.
That ACR are the only consideration which basing on which promotions are considered, my lord.
Understood. But where is the adverse entry mentioned in this order? The impugned order?
Now looking back at the ACR, it is found that so and so are very good once in 2013, good in 3 occasions, and in the year 2010, 11, 12, and average only once in the year 2019. And whereas Shahidul Islam secured grading very good so and so, he never secured average. So she was found, it has been held.
Lordship, merits and ability come when
Para 9, it says, after the above comparative analysis and keeping in mind the directions of the Honorable High Court in so and so, members of the DPC are unanimous of the view that so and so is not found entitled for promotion to the post of supervisory assistant.
So we allow the writ petition.
Ignoring the ACR, my lord, how can there be
Allow the writ petition
average
without
grading-
disturbing Sohidul Islam.
average grading-
Because division bench did not disturb the Sohidul Islam. Luckily, the Sohidul Islam thing has been mentioned. Otherwise, the petitioner will get some more money.
No, that's true, but legally, my lord, because lordship, subject to what your lordship finally decides, my lord, one before the honorable
No, if
single,
it is a case of seniority come merit, the seniority has to be taken.
my lord,
The
seniority
merit,
cum
unless
merit,
you fix the minimum benchmark.
seniority cum merit aspect is there. I have already said that that last observation was unnecessary. There was no requirement. The DPC was only required to see whether on the basis of those 5 years ACR, she can be promoted or not. And if there is adverse remark, the provision
That
of
has
law
not
is
been
there.
considered.
Sorry, my lord.
That has not been considered, adverse remarks.
No, consideration has to
That
be
has
based-
not been mentioned.
No, they have mentioned is in many words saying that comparative analysis.
Where is there mention that she had adverse entries?
Average,
Average is adverse entries.
yes. Average is adverse. If we go by Dev Dutt, my lord,
Means when a person is graded as average,
he'll not get promotion, my lord,
no,
in 5 years.
in every 5 years, if there is one adverse remark,
He'll not get promotion.
show me that judgment.
Devdutt, 2008 8 SCC Milot 725.
What does it say?
Uh,
Isn't it annually?
Milot, may I- 2008 8 SCC 725. This is with regard to communication of the ACRs.
2008?
8 SCC 725. But there is one more judgment, recent judgment as to how to deal with the present situation, my lord.
Yes. What is this?
My lord, this is Amol Satpathy. This deals with a situation, what will happen if the actual promotion is not given, whether he or she will be entitled for notional benefit. He'll have to hold the post.
Yes, where?
But it says, para 20, in the instant case, it is evident that while respondent number 1 was recommended for promotion before his retirement, he could not assume the duties of chief scientific officer. So and so rule clearly stipulates an employee must assume the responsibility of higher post to draw the corresponding pay, thus prevents posthumous or retrospective promotion in absence of an enabling provision. While we recognize
So this paragraph is okay. But the problem lies with the directions passed in the instant case by the division bench.
Division bench, true.
The division bench was wrong then. The
That
division
time,
bench was wrong. But the fact remains that you have not challenged that.
no, that's true. That's
So
true.
therefore, you cannot today raise that issue.
Milord, I am basically on the point that if in the 5 years ACR your performance was not good, you will
No,
not get
only one.
even
One
then.
average. Where is it stated out there in Devdutt
Yes,
that if you have average, you cannot be considered?
Devdutt basically deals with that every
No,
grading has to
you
be,
just said about Devdutt.
yes,
My question is where in Devdutt there is a proposition of law laid down by the Supreme Court that in 5 years, if you have an average, you cannot be considered.
Milord, that has not been laid down. It's
Then
a
that is what I was looking for. You were saying that, then tell me if that be so, because if I am not wrong, in many of these engineering matters, the PWD matters, with the promotion and all, you don't give 0 for average. You give 1 or 2. Excellent, which is there, is 5.
now
Very
the
good
marking
is
has,
4.
yes,
Then good is 3. Average is 2. 1 is poor, and not recommended is 0.
yes,
So you have this grading.
in PWD, yes.
Didn't. Therefore, the very concept of having an average also, there's a marks that's signed out there of 2.
At that point of time, this marking system was not there.
No. At that point of time, my
Gradings
question
were
is therefore.
average, good, very good and outstanding only.
So my question is therefore,
Whether with an average.
can you say that if a person has only average, he would not be getting it?
Because this freedom lies with the DPC.
Understood, but division did not consider it in that line. You are
So in
trying
many
to
words-
develop that too without an affidavit, something which is not there.
May I just, Lordship will permit
We
me
have
one
to
sec-
see the order on the basis of the reasons which have been assigned.
Correct, my lord.
Unless I have to hold that the order which has been passed by the division bench is wrong.
Lordship, comparative merit and ability come when I challenge the post of head assistant. I challenge the post of supervisory assistant, Lordship.
No, now the problem, madam, arises one thing. If you get some financial benefit, the state has a corpus. The state's corpus is that for the post of head assistant, in that particular office is one.
Yes, Lord.
If the respondent number 4 gets the amount, from where would you get the amount? So there has to be an additional budgetary provision provided. How do you take care of that issue?
Yes, I understand.
Problem lies there, not on this what Mr. Das is saying. I'm not all worried on that. He says is absolute. That has nothing to do. My only anxiety is if I put you, because what the division bench did is this. Division bench went into and said that don't disturb Saidul Islam.
Yes, Lord.
Very well. But if you are entitled to financial benefits, now how will you entitled to get the financial benefit unless it is taken out from somebody? There is a one corpus. That is the only anxiety, my question. Answer that. Give me an answer to that. How do I take care of this so that the petitioner can get it?
Lord, otherwise also.
Although for the state it doesn't matter.
No,
They
yes.
don't think about that 1 rupee makes in a sea. It is they think they have a lot of money, they can do anything. But state is not there, but we have to be conscious about it.
Otherwise also, my lord, if
Otherwise, this order is bad.
they
My order
the
is bad.
DPC
But the problem is, how do you reconcile the division bench judgment with this order? So the division bench says, don't disturb Saidul Islam.
yes,
Now, Saidul Islam, you have
they should have
gone
done.
gone into a comparative merit, because it has also been mentioned out there at one portion of that order that go on the comparative merit.
Comparative merit.
Now, once you go into the comparative merit, then it has to be done on the touchstone of the criteria, which is seniority cum merit. Now, once seniority cum merit, they have to fix then the amount on the basis of which they have to fix a minimum benchmark. And if it
Comparative
is
merit.
only based on this, the benchmark is not fixed, then obviously she takes a ride.
The moment we go into this comparative merit, going by Maheta, Lord, it
Don't
becomes
come
a
up with
merit.
all this judgment. This
I'll not come.
judgment has nothing
No,
to do.
no, this is-
Devdutt had nothing.
No,
Don't
this
keep
is
up
with regard to
coming
advancement.
with any.
Milord, I'm not going into. Milord, if the moment we do comparative merit, it goes into the merit cum seniority. That's the problem, Milord.
No, you cannot. That is
So
wrong. Therefore, the division bench order is wrong in that
We are
regard.
in a flux situation, perhaps that's why this, because it was in compliance with the Honorable Division Bench's order, Milord.
Now,
But the
because of
fact
the-
remains the DPC
because the
should have.
division bench order says don't disturb him.
Exactly.
But on the other hand, consider as to whether she will be entitled to any additional financial benefit on account of a promotion. But you again look into the comparative merit
Because
without touch saying as to how it is to be done when it's a case of seniority cum merit.
in fact, the DPC should not have gone with the seniority cum merit.
They had
DP
to go.
No, DPC should have considered the 5 years ACR. Since 4 is gone, there is no requirement of going into the seniority cum merit issue. DPC should have considered the 5 years ACR, whether remarks on the basis of remarks of those 5 years ACR, she can be considered for promotion or not.
Can the court, whenever there is a direction for a reconsideration, has to be done as per the rules?
This
The
is
rules
re-
categorically means seniority cum merit.
No, Lordship will appreciate. In the meantime, both of them, the petitioner retired. She will not go and hold the post.
We do one
Only
thing.
notional benefit is
Madam.
required to be given.
We do one thing. Get hold of Mr. Mr. Bonik.
Lord.
Okay? Because then I'll put that question to him. That why didn't you challenge this before the Supreme Court, the judgment where it changed the criterion from seniority merit to merit?
And this seniority cum merit issue neither was argued before the honorable single judge in the earlier round of litigation, nor before the writ appeal. And before the honorable single judge, the petitioner made a submission that we don't have any issue with the remarks in the ACR. That was recorded by the honorable single judge.
That is okay. I'm not on that. But therefore, let's get hold of Mr. Bonik and then dismiss it in his hands. For you, it's okay. That is the only way out for this court to escape.
So, this court never escapes, my lord.
Not to put the division bench, or in other words, not to put the division bench into embarrassment.
But I think, my lord,
Because the division bench was apparently wrong.
apparently no.
Because division bench ought to have thought about it, that the order should have been on the basis of there could not have been a comparative merit taking into account the criterion was seniority cum merit.
Correct. Simply,
So the division bench made the criteria merit, which is absolutely illegal.
simply the division
Can
bench
we
should have
say that the division bench order to be per incurium? Because per incurium, if we see the barium chemicals judgment, it will also include without taking into consideration the merit, consideration the rules. It will definitely come in. Then what will be the impact on the reconsideration? Then can I pass an order to that effect that the horse, what has the division bench said, it being per incurium, the DPC, again another DPC would be there on the basis of seniority cum merit. Would it be possible on my part to do that? These are questions which your senior will address. Okay, better off. This is the only way out.
My lord.
Otherwise, if your senior comes, then obviously I will take it up on that issue. Why haven't you challenged it? And can you now raise this issue? When there is a comparative merit has been directed. Because his submission is to the effect that it is seniority cum merit.
Yes.
That is your case.
Yes. Lord.
Now, can you raise that issue after getting that order from the division bench? You should have argued that only. Because I cannot do anything. They have therefore done it rightly.
Next week, Lordship. Then Lordship next week.
Next week. Next week, but if he doesn't come, then I'll dismiss it at your hands. Okay? The main consideration is different. The reason why I'm saying so. Because the problem which arises is, if I give you the amount, an additional amount, where is the state going to pay? Because the state's funding is only as regards one head assistant, isn't it?
Yes, Lord.
Supervisory assistant. my lord.
Whatever may
Yes,
be.
yes, correct.
Rose is a rose in whatever form it is.
Yes, yes.
Okay, let's taking into account that Mr. S. Bonik,
Hmm?
the Learned Senior Counsel appearing on behalf of the petitioner is not present today. Matter stands adjourned to be listed again on 23rd of July 2026 for final disposal.
Your Lordship, I am praying for adjournment for 2 weeks, my lord. My senior is out of station for his treatment, my lord.
Your matter about.
My lord, here, one office was provided by the ONGC to the union. And two, my lord, groups are fighting, so we have locked it.
Very well.
Against that, they have come. We say that you mutually come, we are opening it.
Trade Union of Oil and Natural Gas Commission Workers.
Yes.
And Mr. Dasgupta, you are appearing for which trade union? You are number 6. He's for another trade union.
He's also retired, sir.
Huh?
He has been retired.
You have retired.
Yeah, he has been retired.
No, he cannot retire. He's a union. Petitioner is a union. You may retire.
Yes,
But madam, isn't it a civil dispute?
No, my lord. The
If it is
petitioner
a case
recommended
where
nothing.
the ONGC have locked the premises,
yes.
so to go fight it out before the civil court as to who has the right over this land, over this area. I think both of you need to fight before the civil court. This court should not touch it. You are the General Secretary of Trade Union of Oil and Natural Gas Commission Workers. Okay. You say to be the General Secretary. He also says to be the General Secretary, isn't it? So, one trade union, there are two groups. It's an internal dispute, civil court, no case. This case cannot be there. Don't spoil your time here. I have heard Mr. So-and-so, the learned counsel, Ms. So-and-so, the learned counsel appearing on behalf of the petition. Mr. G.N. Saiwala, the learned senior counsel, appears on behalf of the respondent number 234. Union? You are union? Okay, Mr. J.K. Goswami appears on behalf of respondent number 1 and 5. Mr. So-and-so appears on behalf of the respondent number 6. Hey, G.N. Saiwala assisted by so-and-so. It is the Gupta assisted. You have a junior assisting you? Yes, give you. The present petition has been filed. By a trade union. Who won Sri Ashok Boydya, who claims to be the General Secretary of the said trade union. On the other hand, it is seen from the records that a respondent number 6, namely Sri Hiresh Chakraborty, also claims that he is the General Secretary of the petitioner trade union. The materials on recall also show that there is a dispute between two factions, two groups claiming rights over the petitioner trade union. And it is under such circumstances, the respondent number 2 have taken steps for the purpose of locking the office of the trade union. Under such circumstances, both the petitioner has approached this court by filing the present writ petition. Under such circumstances, the trade union, namely the trade union represented by Sri Ashok Bodhya, the petitioner trade union represented by Sri Ashok Bodhya had appeared before, have filed the present writ petition challenging the action on the part of the respondent number 2, 3, and 4 in locking the said office. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the perusal of the materials on record, it is apparent that there are two factions oblique groups who claims to have the control over the petitioner trade union, namely the Trade Union of Oil and Natural Gas Commission Workers, Kachar Project, Silchar. It is the opinion of this court that the dispute between the two groups as to who controls the trade union, the petitioner trade union, is an apparently a civil dispute which can only be adjudicated before the competent court of civil jurisdiction. Considering the above, this court is not inclined to entertain the instant writ petition. Before parting with the record, this court, however, finds it pertinent to observe that once the issue as to who controls the petitioner trade union is resolved, the respondent numbers 2, 3, and 4 would be required to provide the space for the trade union.
Well,
And this aspect, Mr. G.N. Sahewala appearing, the learned senior counsel appearing on behalf of the respondent numbers 2, 3, and 4 submitted that the said respondents have no dispute. And it is only on account of the two groups fighting over the control of the trade union, the office had to be locked. First, this court further observes that the dismissal of the instant writ petition on the ground of not being entertained shall not prejudice either the petition either of the groups who claims to be controlling the petitioner trade union to approach the competent court of civil jurisdiction.
Right.
What happened now? File that affidavit.
File two affidavits, my lord.
What is it now? What is the present state of affairs?
Affidavit, my lord, one by the commission. One by the PCCF. My lord, the area falls on the buffer. But it also forms a part of a reserve forest. Two reserve forests were combined together and these are the national wildlife sanctuary was declared, my lords. So as of today, my lord, though it's a buffer area also, it's a reserve forest.
So
I
there
don't-
cannot be any non-forestry activity.
My lords. Yes, my lords.
Notes will kindly,
This statement given.
well, this affidavit filed by the Commissioner Secretary at 480, it starts at 482.
Commissioner and Secretary, Environment
Yes,
and
ma'am.
Forest. Is the highest authority?
Yes, at present he is the highest man.
Has been filed on the factual report dated submitted by the office of the Imam that directed the report. Which there was a memorandum which lies within the core area or the buffer area. Thanks to the aforesaid. Within the notified subsequently by buffer area. So you are going to have ecotourism there.
My lords, it's permissible, but they have to adhere to the guidelines of 2012. It's with the book, my lords will find there's a.
My lord, insofar as this guidelines normative standard is concerned, my lord, we already have filed an additional affidavit long time back, and we have already brought on record this aspect of the matter, my lord. We have clarified our position quad at normative standard, my lord. If your lordship takes up that affidavit, my lord,
It's okay. Wait. So therefore, you are going to allow ecotourism there.
My lords will allow, but they have to stick to the guidelines, my lords.
So if they stick to the guidelines, you are going to allow?
Well, that will look into, my lords. They have to, they will look into, my lords, that they have to adhere to the guidelines. They have to apply to us because there's a certain guidelines of 2012. It covers the field, my lords.
You do one thing, you apply.
my lord, what has happened, my lord? I just,
Mr. Zha,
lordship,
you apply. You see,
lordship.
you apply. Let them apply and then
Yes.
you come up.
Only one aspect, my lord. That
Mr. Rahul, you are not getting the point.
I'm getting the point, my lord.
He says that he's going to, you categorically say that you are an ecotourism.
Lordship.
They also say that the ecotourism would be permitted. Because at one point of time, Mr. Gogoi had made a categorical submission that nothing can be where it is in the core area.
area.
Yeah.
Now, my lord.
Now, therefore, I directed the PCCF or anybody to file an affidavit. Now, the affidavit which has been filed out here categorically mentioned that it is not in it is within the reserve forest, but
It's
it
a
is in the
buffer zone.
buffer zone of the Tiger Reserve Forest. Okay. Now, they also mention out there that they will be permitting the ecotourism. Now, if they're permitting the ecotourism out there, then in that regard, whether by way of the ecotourism is, you categorically say that yours is an ecotourism,
Lordship.
you apply. And let us get a report from them.
My lords.
Better off.
My lords.
Heard Mr. G. Rahul, the learned counsel, appearing on the petitioner. Mr. Mr. D. Gogoi appears on behalf of the Department of the Government of Assam. When the matter was taken up by this court on 30/3/2026, the D. Gogoi, the learned standing counsel of the Forest Department, referring to Appendix A and Appendix B to the Wildlife Protection Act 1972, submitted that the eco camp is situated within the core area and that the area has to be treated as a sanctuary in terms with Section 33 of the Act of 1973, read with Section 38 V, capital V, of the same Act. It is under such circumstances this court directed the Principal Chief Conservator of Forest to bring on record by filing an affidavit as to whether the eco camp, in respect of which there was a memorandum of agreement with the petitioner, lies within the core area or the buffer area of the Namari National Reserve, Park and Tiger Reserve. It is seen that in pursuance thereto, an affidavit has been filed by the Commissioner and Secretary, Environment, Forest and Climate Change Department of the Government of Assam on 22/5/2026. Paragraph 5, 6 and 7 of the said affidavit, being relevant, is reproduced hereunder. From a perusal of the above content, above quoted by page 484, 484, 485. From a perusal of the above quoted paragraphs of the affidavit filed on 22/5/2026, it will be seen that the area wherein the petitioner had set up the eco camp do not fall within the core area, but rather falls in the buffer area of the Namari Tiger Reserve. The respondent number 1, by way of the said affidavit, had also categorically mentioned that ecotourism is permissible within the guidelines as laid down by the Supreme Court in the case of T.N. Godavaran Tirumulpad versus Union of India and others, reported in 2025 INSC 1325. You are an eco development committee.
My lord, they are
Lordship.
angling society, my lord.
My lord,
Angling.
My lord, what has happened, my lord? It was way back in 1995. Much prior to these rules came into vogue, we have been in existence, my lord.
It's okay.
Providing eco facility, my lord, which is eco-friendly, my lord.
Taking into account that the petitioner claims that it is in the business of ecotourism, You are in the business of
We
ecotourism.
are providing eco-based shelter to my lord.
Are you in the business of ecotourism or
Not
not?
directly in business, my lord. Not in the business. We are not doing any business, my lord.
You are not taking money.
Some revenue is collected, but it is not business, my lord.
What is that?
My lord, it is for the villagers, my lord. It is for the welfare of the villagers, my lord. The society does not earn any profit out of that, my lord. My lord, it is originally it was sponsored by my lord donor, my lord, who
It's okay. Are you in any way connected with ecotourism?
yes, because we have just
My simple question is, are you in connection with ecotourism? or
yes,
not?
yes, my lord, yes, yes,
But it is only ecotourism which is permissible.
yes, lordship.
So you are in the business of ecotourism.
We are doing ecotourism. Yes.
Taking into account that the petitioner claims to be in the business of ecotourism, thereby providing facilities for the development of the local communities.
Okay.
Leave is granted to the petitioner to submit an application before the whom? Before the respond number?
My lord, it will be the my lord, National Tiger Conservation Authority, my lords, NTCA. Those guidelines are my lord, managed by them, my lords.
No. It will be given to the PCCF and PCCF will forward it
My lords. Please.
with an application to the National
Tiger Conservation Authority, my lords.
so and so. To the PCCF of full নাম তো লিখে দিব principal. Within how much time?
My lord, 1 month, my lord.
Does 1 month is required for the purpose of submission of an
My lord,
application?
we'll have to find out their criterias and then accordingly we'll have to place.
Within not 1 month, 15 days. Within 15 days from today. And thereupon, upon receipt of the said application, the PCCF, Government of Assam, shall forward it to the head to National Tiger so and so. This matter again on 5th of October 2026 and an update be provided as regards the outcome of the said application.
My lord, may I just make a simple prayer, my lord? Till then, my lord, the operations have been interfered by the.
Absolutely, you cannot operate. You have no permission.
My lord,
You have no permission. You have not been operating since the filing of the writ petition. Have you been operating?
we were operating, but
Have you been operating after the filing of the writ petition?
stay was obtained, my lord. Lordship was inclined to grant the interim protection, my lord.
Interim-
We started operating. Again, they started interfering, for which we, my lord, filed a contempt also, my lord. But it is now, my lord, there is an impasse, my lord. So if I may pray, my lord,
No.
at least let the because the facility.
Whatever is there, however it is there, if you are operating, keep on operating. If you don't operate, you don't operate.
No.
That is yours. I'm not going to pass it.
God bless, God bless.
Hey, for what?
I understand.
I am not pressing right now, my lord. That's
I'm not pressing this.
no, not right now, my lord. Let it be taken up, my lord, together up on 5th of October, my lord.
Now, you are asking for stay of some or letter dated 15/9/2023 issued by respond number 6 directing not to interfere with the operation of the ecotherm at Nameri by the petitioner association till the disposal of the writ petition. Then after an order,
No, my lord, it was
observe that if there is no response, taking into account the word, this court fixes the matter, thereby directing the to bring on record its end. The petitioner.
Hmm?
I'm not passed any order there.
My lords.
No, my lord.
So it is happening from 2023.
No, sir.
And now in 2026, when I'm asking you to file an application for seeking permission, you want to allow this application.
There's some protection, my lord. That
You have already been protected, whatever protection is that not to give it to any third party. I'm only
Okay.
maintaining that. Let's see what happens. Because your right is on 9.
No, sir.
You see, your thing is, unless these circumstances does not exist, which is mentioned in 9, the memorandum of agreement continues.
Continues, my lord.
That is your case.
No, sir.
Now they have discontinued the agreement for which you filed the writ petition. I have said initially that not to give it to anybody else. That is one. Now, there was a problem which was there in view of the order passed by Justice Medhi, which was later on corrected or clarified to that effect. In the meantime, when the matter came up, you raised the issue that there are many others who are functioning. Now, thereupon, I sought for an inquiry. Upon inquiry, it was found that no, nothing to that effect. They say that some are there, some have stopped, and all these things they have stated. Then, thereupon, an issue as was raised by him
Right.
that it falls within the
Under
core
core
area.
area, yeah.
Therefore, I asked the PCCF to pass or file an affidavit. Now, the commissioners categorically says that it is not, it is in the buffer area by which ecotourism can be permitted.
No, sir.
Therefore, I'm asking you to file an application. Once you file for a year, then let an update be given to me.
No, sir.
Think about the future,
No, sir. No, sir.
not the now.
Always.
Obliged.
On his behalf. I'll appear on behalf of Anboro. Your Lordship, I'll appear on behalf of my senior Anboro for the petitioner. Your Lordship, the matter relates to family pensionary benefit. As per order dated 30/4/2026, the petitioner has appeared before the district judge, Lakhimpur, who is the respondent number 3 in this matter, and have submitted relevant documents. This
We have received the report. And as per the report, the document shows that the petitioner is the wife of.
So now you are going to take it up.
Your Lordship, we rely on the inquiry report for appropriate orders.
Now, in view of this report, the necessary things you are now to forward it so that the pension people.
They have to submit the claim, my lord. That is papers for pension, my lord. The petitioner has to submit before the authority. That is response number 3.
Order,
Response number 3, man.
which is the response number 3?
District and session judge, Lakhimpur.
Help out the petitioner, she is 75 years old. The order dated 30/4/2026. Whereby, by the so and so. Good. Yeah. The B Chakraborty. Okay, but we record his name. By an order passed by this court on 30/4/2026. This court directed the respondent number 3 carry out the verification as to whether the petitioner is the wife of late Rupesa Borgohain. On the basis of the directions passed by this court on 30/4/2026, the district and session judge Lakhimpur, not Lakhimpur, have placed the verification report before this court along with its enclosures. The verification report along with its enclosures are collectively kept on record and marked with the letter Y. From the said verification report, it is apparent that after scrutiny of the various documents, including the original half of the pension payment order, it was opined that the petitioner was the wife of late Rupesa Borgohain. Under such circumstances, the petitioner is entitled to the family pension. Considering the above, this court directs the respondent number 3 to take appropriate steps with the respondent number 2 and 4. 2 and 4, not 2.
One proceed. Now, Lordship, it is the Pension and Public Grievances Department. Two, it is Director of Pension. Public Grievances.
With whom?
One.
With the respondent number 1 and respondent number 4. So that the petitioner receives the family pension. List this matter for an update on 24th of September 2026.
Meanwhile, petitioner also will go.
The petitioner would also, in the meantime, provide the necessary materials if so required. Before the respondent number 3. This court further observes that taking into account that the petitioner is already 75 years old, the respondent number 3 will provide the adequate assistance so that the petitioner receives the family pensions along with the necessary arrears at the earliest. I've kept the matter pending so that let's get an update. Once the matter is there, then
Item 7 to 12.
What is the status?
One letter has come, perhaps, my lord. I don't know what type of this clarifications asked. My lord, with all due respect, I find these clarifications to be very strange. Although, my lord, my instruction is that, my lord, a note will be put up before the Honorable Chief Justice in the administrative side, my lord.
What is wrong with your officer? What is wrong with your LR? Is he not aware of it? The finance has already okayed it. The legislative department has already okayed it. What is wrong with your LR?
Employment generation potential.
All things have been taken. Is he not aware of it? It is only to be placed before the Legislative Assembly. That is what has been the final concurrence. Everything has been done. Initially, which was made in 2015, then it has been again remedied at the request of the Legislative Department. Legislative Department has said, okay. What is this? We'll have it next week. Ask the LR to be present in the court. This is not how we expect this LR to be functioning.
Lordship, although Lordship,
Mr. Goswami, are you aware about the history about this case or not?
yes, Lordship.
You ask your Mr. B. Gogoi to appear, not you. Ask Mr. B. Gogoi to appear. You take up the matter of person. This is not done.
Item 13 to 15.
My lord, this matter pertains to regulation of sweepers, my lord. In Khushbu matter, I think OM of the Finance Department has been challenged, my lord. That's why your lordship take this matter with these matters, my lord.
What is the stand of the Finance Department?
Finance Department says as per their affidavit, my lord.
In which case they have filed the affidavit?
Item number 13, my lord.
Shankar Baspor.
Yes, my lord.
Yes,
Their
my lord.
affidavit says, my lord, sweepers who are working in government hospitals, my lord, only they are entitled. They have stated in their affidavit, paragraph 6, my lord. As per this OM, my lord, filed by lordship. Response number 2.
Joint LR.
Page 97.
Yes.
Paragraph 6, my lord. Category stated that, my lord, sweepers shall not be their outsourced in government hospitals as per the stand of the government, my lord. As per government hospitals who are working as sweepers, they are entitled, my lord.
You have challenged the OM, no?
I am not challenged, my lord.
Somebody has
In
challenged.
item number 15, no, 14,
Where is the other
Mr. Das,
counsel?
Mr. Das challenge, my lord.
Yes, finance. What do you have to say on this?
No, Khushbu.
But Khushbu Basma, we have filed the affidavit.
Yes, he have filed, but there is another case where that OM has been challenged in respect.
Yes.
Why in the hospital there is a requirement of sweepers post, but not in the courts?
That is a policy, my lord,
The
because
policy is okay, but the policy has to be based on, yes, in your offices it is okay. I'm not concerned with your other officers.
Lord, sir.
But in the courts, it has to be in an independent thing. On one hand, there is a huge hue and cry on the basis of various orders passed by the to the effect that there is a requirement. Having toilets and all,
My lord.
toilets are being constructed. Who is going to clean it? If you don't have posts for that, can't we take it as a part of the directions passed by the Supreme Court in that judgment of Rajiv Kolita, wherein the categorical observations out there that there has to be toilets, and if there are toilets, there has to be persons or posts created for the toilets. How do you take care of that situation?
That, my lord, of course, I can take up with the authorities, my lord.
No, it has to be there because of the fact that otherwise it will be violating the Supreme Court's directions.
Then Lord, we will, my lord, post it in the infrastructure bench, then this part can be looked into instead of. going
Here
to
he
the-
had challenged the OM
But even then, my lord, if the authorities now, my lord,
because there the toilet aspect has been taken up.
yes.
Now, if you don't create posts, yes, for others, I'm not concerned about all other your officers that how you manage. For hospitals, you are doing it.
Yes, yes, required.
The reason is you need these sweepers
Lord, sir.
because you have to have these toilets. Like in all other departments, whether you or not, it's a different thing. But when there is a direction by the Supreme Court and there are categorical directions also for creation of post, that direction,
Lord, sir.
for payment of money, all these things are there, then can the directions passed in Rajiv Kalita say that, okay, it is overshadowed by the directions by the office memorandum of the finance department?
I just assist. Office memorandum say the sweeping and cleaning services are to be outsourced and post of sweeper shall not be filled up in any department. It's a, OM says about department, whether the.
Because the finance department considers the Gauhati High Court and the district judiciary to be a part of the judicial department.
My lord, so far as my lord, clause 3 and 7 is concerned, my
I
lord,
don't
of
think-
the OM, that has been relaxed for the High Court as well as the subordinate. Lord, we will see page 134. That has been relaxed.
Page 1. 130.
134, running page, my lord, 134, part of our affidavit. 3-year clause.
Your affidavit starts and finishes. Which one? The office
My lord,
memorandum,
1185. of
filling up
2000
of vacant post.
regarding SIU approval and all, that has been relaxed.
No, that is okay.
What I am saying is, my lord, probably. my
No,
lord,
that
if
is okay.
this
but
issue
only-
is taken up, then we can look into that aspect too.
Yeah, number 8, sweeping and cleaning services are to be outsourced and post of the sweeper shall not be filled up in any department on any ground, including compassionate grounds, except in government hospitals as per the stand of the government already submitted before the Honorable High Court and the judgment issued based on the stand, contravention thereof shall entail personal liability. Now, this particular is on the basis of a High Court judgment.
Yes, it says so.
It's a High Court judgment. We are concerned with the Supreme Court or the judgment in this regard. So, in view of the Supreme Court judgment in Rajiv Kolita, yes, Rajiv Kolita talks on RAJEEB. Rajiv Kolita and the directions passed therein, can't help it. Now, once the posts are being created, then the question of regularization will come.
Yeah, again, there will be several.
Now, that is another aspect. But he had challenged that office memorandum.
Yes.
upon due advice by Mr. H.K. Das. Because I can't put this matter in the infrastructure bench. I can't. In the infrastructure bench, while doing it out there, I take up this office memorandum, it's a different aspect. Although it is the same judge. But this has to be gone to the Chief Justice and the Chief Justice has to put it in that infrastructure. I can't put this in that. So therefore, you answer to this.
Yes, whether this.
Whether it would not be contrary to the judgment in Rajiv Kolita.
Lordship, I will have that.
বলেনি রাজীব কলিতা তো
2023 SCC online SC 2320 million. 2023 SCC online SC 2320.
No, the judgment is
2025. Yes, your chips.
SC online SC.
SC 81 millions.
In the instant batch of petitions, amongst others, there is a challenge to the office memorandum data. There is a challenge to clause 8 of the office memorandum dated 33/2012, whereby challenge to the year. Full stop. In terms with clause 8, sweeping and cleaning services are to require. In terms with clause 8, it is mandated that sweeping and cleaning services are to be outsourced, and post of sweepers shall not be filled up in any department on any ground, including compassionate grounds, except in government hospitals as per the stand of the government already submitted before this court, and the judgment issued thereon in WPC number 10447/2003, based on the said stand. Full stop. In the instant case, it is relevant to observe that the Supreme Court, in the case of Rajiv Kolita versus Union of India, reported in 2025, SCC online SC 81, had categorically held that toilets, washrooms, restrooms are not merely matters of convenience, but basic necessity, which is a facet of human rights. Access to proper sanitation is recognized as a fundamental right under Article 21 of the Constitution, which guarantees the right to life and personal liberty. The Supreme Court further issued various directions in the said judgment. To ensure that thereby that issued various directions that the high courts as well as the state governments UTs shall ensure that construction and availability of separate toilet facilities for males, females, PWDs, and transgender persons in all court premises and tribunals across the country. Further to that, the state governments the UTs were directed to allocate sufficient funds for construction, maintenance, cleanliness of the toilet facilities within the court premises, which shall be periodically reviewed in consultation with the committees constituted by the high courts. Paragraph number 10.1, 10.2, and 11 of the said judgment being relevant are reproduced hereunder. In the backdrop of the above directions, the question arises as to whether the respondents respondents of the state of Assam the question arises as to whether clause 8 of the office memorandum dated 30/3/2021 can continue to remain qua the courts in view of the specific directions passed by the Supreme Courts. That there is not only a requirement of providing facilities for toilets, but also for maintenance. And if posts are not created for the sweepers, for maintaining the toilets, wouldn't it be contrary to the directions passed by the Supreme Court in the case of Rajiv Kolita, Supra? Mr. B. Gogoi, the learned additional AG who appears on behalf of the Finance Department, shall obtain necessary instructions in that regard and file an affidavit. This matter on 20 August 2026. The said affidavit be filed on or before 17th of August 2026. Mr. Gogoi, this is one aspect. The other aspect is the rules. You remember those rules? Yes. Initially, the finance has said okay. Right. Thereupon, the legislature department said that okay, they made the draft. They gave the introduction. We made corrections. We sent it back. They said okay, everything. Right. Now, what are they asking? Look at the conduct of your LR.
Let it be on Thursday next month. That I will have the instructions.
I'm very disappointed with your conduct of your LR. Is he not aware of it? In fact, this is a case which needs to go to the infrastructure bench. Because of the rules, these persons, the finance has said okay. Because they know that these are the posts which are being created. There are no additional posts which have been created. These posts are exactly created as per that. The legislative department said that yes, it has not been framed out in a particular manner. So therefore, the Advocate General appeared and he said that the Secretary of the Legislative Department shall formulate or frame the rules and send it to us. Accordingly, the Legislative Department Secretary made it and sent it to us. Now you are asking these things which are already been provided a long time back. Ikida. Mr. Das, first get this thing done. Then we apply Dharam Singh. নহয়। এই তিনটাতে এটা order. এইকেইটা নহয়, এই আগৰ case কেইটা।
7 to 12.
The present batch of petitions have been postponed from the adjudication of the present batch of petitions have been postponed from time to time. On the ground that the draft ministerial that the Assam district and the draft Assam District and Subordinate Court Employees Service Rules 2025 is under active consideration of the said rules being made. This court also takes note of the various and it appears therefrom that the Finance Department of the Government of Assam as well as the Legislative Department of the Government of Assam have duly given the concurrence. It's, however, shocks and surprises this court. Take note of a communication issued by the LR and Commissioner and Secretary to the Government of Assam Judicial Department, whereby further informations have been sought for from the Register of Vigilance, Gauhati High Court. It appears that the LR and Commissioner and Secretary to the Government of Assam Judicial Department is unaware of the presence of the various steps which have been taken so that these rules can, the said rule, these rules which are the need of the hour can be made at the earliest, as it is causing a lot of administrative inconvenience in the functioning of the ministerial staff of the district judiciary. Mr. B. Gogoi, the learned additional AG, Assam, submits that he would obtain necessary instructions in this regard. List this matter on 23rd of July 2026.
F16 and 17.
Oh, this matter. What is the name?
Scrapping winch.
Winch. Winches. Scrapping winches have become how many litigations here? Oh, till now. This is the fifth, sixth. Now tell me.
Lordship will take the review petition.
Yes, review.
Lordship, initially we had filed the writ petition only on the basis of the information that was available from the technical list. So what has happened, all the names of the bidders were shown as MSME and the name of the L1 was not shown as MSME. So we presume that if he is not MSME, we should also get, because a chance to offer, we are in the 15% zone. So we should get a chance to match the L1, because he will only get 75%, then 25% will have to be given there to other MSMEs. So that was my case in the first round of litigation, that we should be given a chance to match the price of the L1, and the 25% should be given to us. But on the date of the motion hearing, the documents were submitted which are not within our knowledge, that to show that he has participated as MSME. So accordingly, the reputation was disposed of. Subsequent to that, we have come across.
So therefore, your review is subsequently you have come to learn about other materials which were not otherwise available.
To me.
And as such, on discovery of new materials which was not available, you have come and filed the review.
Yes, yes.
There are some further facts in between. What had happened was, the earlier writ petition, your lordship in fact, my lord had the occasion to deal with that litigation also.
I had dealt with 4.
Maybe even more. I have lost track. That writ petition, for whatever it was worth, it was dismissed on merits. Thereafter, he claims that new materials were discovered. He filed a writ petition. In the writ petition, we raised the specific plea of, in addition to other technical grounds, we raised the plea of constructive res judicata. Once we took, and the other interesting thing is, he completely suppressed the earlier judgment. We placed that on record, and we also raised the plea of constructive res judicata. Once we filed that affidavit, now this review petition has been filed. So whether your lordship will allow such kind of conduct in a writ proceeding, that is the further issue that will have to be perhaps precise. On merits also, we have answered.
That is okay, but the fact remains that this is a fact. Unless you show that this fact was available to him. This fact was available to him at the time when I delivered the judgment in the earlier round of litigation.
So that we are not disputing.
So therefore, with all due diligence, he could not come to learn about that thing.
That due
I'm
diligence,
not on this petition, but in that petition I'm saying. Yes, in this petition, he has a problem with the constructive res judicata. In fact, the moment I allow the review out there, I have to allow him to file an affidavit and then close this petition. Because this is a fact which has to be now brought in this petition.
no, in the earlier petition, which is under, which is under
petition, he has to bring that back. In fact, the second petition is not maintainable.
the writ petition is,
The second writ petition is not maintainable. He has to therefore seek for a review in this matter. And once he gets the review, he has to file an affidavit. Then he files that affidavit you have to get a right of response. The first writ petition, then the
in fact,
second writ petition, which has been subsequent writ petition, becomes infructuous.
in fact, by now he should have, when he filed the review, in my humble understanding, he should have actually withdrawn the writ petition.
Hey, don't go and
I'm not.
Ashram, although he is very technical when he makes his argument. We allow his review. On that day, I wanted to allow the review, but we allow his review. These facts were not available to him to file an affidavit, and then this has become infructuous. That is the way we close this.
Only issue is again slightly
But we keep
technical.
the records, we keep their records of dates, tagged with dates, so that you may not like to read, or you may file a short affidavit out here, thereby relying on the record.
The only issue is, but again, I might sound a little technical. The only issue is the issue of due diligence. He always had the opportunity to file a RTI application on all these issues that he now says that he has discovered later. Because these materials also, he has, I think, gathered through RTI only. That is something he is totally silent in the review. Whether he has exercised due diligence.
What is your point now?
Your Lordship, there were two MOUs that the bidder has to submit.
But now these MOUs, some they did not have that
Signatures.
some MOU or did not sign.
Signed those.
That MOU, that document was made available at the time when the technical bids were open.
It is their own stand and there is a letter to that effect if your Lordship sees page 247.
Of which
The review petition. Hence, it is requested. Hence, it is requested that the referred future visibility of bids to all the participant bidders after the bid opening may be disabled at organizational level for ONC tenders. No bidder should be able to see bids, tender documents of other participating bidders of the tender. Further, participating bidders should also not be allowed to see the letters seeking clarification, shortfall documents issued by ONGC or the shortfall documents submitted by the other participant bidders during. So these documents were not available to us or we are not able to see during the opening of the bids. We only came to know the list. We were only able to see the list who were the technically qualified and thereafter after opening of the financial bid who was L1, L2, L3. Just a list.
Which are the two documents you are referring to?
Yes, your Lordship will 190. (190) is the agreement for supplying of winds. 190. 190, that is the supplier signature is there. 190, 191 and 192.
Signature is not there.
Not there. And in the other one for the supplier of the vehicle, the truck, that's 187. Here, both the signatures are there in 2 pages. But in 189, the 189, the bidder signature is not there, 189. It starts from 187.
This is an heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, review petitioner, and Mr. Ari, the learned senior counsel assisted by P. Bulwa, appears on the ONGC. Respondents. Respondents, huh?
Sorry?
They are the respondent numbers?
124.
124. And so appears for respondent number 5. This is a review application file seeking review of the order dated 26/9/2025 passed in WPC number 5768/2025. Only on the ground that the petitioner, subsequent to the judgment, passed by this court on 26/9/2025, discovered new and important matters of evidence, which the petitioner even with due diligence would not have come to learn about these important matter of evidence at the time when the earlier writ petition was filed, as well as at the time when the judgment and order dated 26/9/2025 was passed. The important matter of evidence are the documents which have been enclosed as Annexure 3 and Annexure 4 Coli to the review application. Annexure 3 is the purchase agreement. And Annexure 4 is the agreement entered into by the respondent number 5 with one MS Quick Edge Integrated LLP, who is the manufacturer and supplier of scrapping winches. It is the specific case of the petitioner that these two documents would show that these documents are incomplete in nature and without and such document could not have been taken into consideration by the respondent numbers 1 to 4 at the time of evaluating the technical bid of the respondent number 5. Mr. I. Chaudhary, the learned senior counsel, appearing on behalf of the respondent number 1 to 5. Though fairly had submitted 1 to 4, though fairly had submitted that the respondent number 1 to 4 do not question the due diligence, but the petitioner could very well file, could have very well, do not question the petitioner's lack of knowledge about these documents, but questions the due diligence of the petitioner on the ground that the petitioner could have filed in applications under the Right to Information Act 2005 seeking these informations.
But I'm sorry to interrupt. This is in context of his own statement made. Even now, if your lordship sees, he does not describe how he comes into possession of these documents. When he is stating, he is merely stating like this one. Petitioner came into possession of 2 new documents. That is the only statement made. So, to show that he had exercised due diligence, there is no statement in the entire review petition. Para 9, if your lordship sees, at page 9.
Of the review petition.
Review petition. In 2 places, he has stated about coming into possession, but he does not say how. The very first sentence of para 9 at page 9, and then he repeats a similar vague statement at page 10 down below. Page 10, again he repeats, he simply says, last sentence in page 10, the petitioner discovered the aforesaid document. How he is not even attempting to.
Yes, how did you get it? How?
Af-
How did you get it? Huh?
We didn't get it from the portal though.
Hmm?
We didn't get it from the portal, but client came into the possession.
Now, are these documents still available in the portal?
Otherwise available. According to him, it is there in the portal.
As of now?
It is there in the portal, but it is not open, visible to everyone.
Bidders?
It's not.
Like for example, if I submit my bid, I can see it because these are all personal documents. So
I cannot.
So therefore, this
document, respondent number 5 will not be able to see. Respondent number 5's document, he won't be able.
The learned senior counsel for the petitioner, respondent numbers 1 to 4, further submitted that a perusal of paragraph number 9 and 9N
Para 9, it is a continuation of para 9.
of the review application will also show that the petitioner have not disclosed the source of the said two documents have been enclosed as Annexure 3 and Annexure 4 colli to the review petition. Per contra, Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submitted that that as of now also, the said documents are not available. The petitioner is not in a position to see in the portal. But somehow the petitioner could manage to get the document only recently and immediately had filed the review application. And as such, the petitioner had due diligence. Taking into account the above, and without commenting on the impact of Annexure 3 and Annexure 4 colli in the to the technical bid or in respect to the technical bid, in respect to the evaluation of the technical bid of the respondent number 5, it is the opinion of this court that the petitioner has been able to make out a case of discovery of new and important matter which touches on the technical evaluation of the respondent number 5 and which was not available to the petitioner at the time when the writ petition being WPC number 5768/2025 as well as the judgment and order dated 26/9/2025 was passed. Accordingly, this court therefore is of the opinion that the impugned judgment and order, the judgment and order dated 26/9/2025, passed in WPC number 5768/2025, stands recalled only to the extent of consideration of the new and important evidence, that is Annexure 3 and Annexure 4 colli to the writ petition. However, in respect to the other aspects which have been dealt with already in the judgment and order dated 26/9/2025 in WPC number 5768/2025, stands finally concluded. The review petition accordingly stands allowed. The main petition for 5768. In view of the allowed and stands disposed. In view of the order passed in view of the order dated so and so passed in review petition number 82/2026. The writ petition being WPC number 5768/2025 stands restored, is taken up. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to file additional pleadings as well as bring on record the Annexure 3 and Annexure 4 colli to which of the review petition in the instant proceedings. 3 weeks, how much time?
2 weeks. 2 weeks.
He submits that the said additional affidavit would be filed on or before 27th of July 2026. Liberty given to the petition respondent numbers 1 to 5 as well as respondent numbers 1 to 5 to file reply and affidavit in opposition to those additional pleadings. How much? 2 weeks?
The lordship can fix it either on 11th or 13th. We'll file it before that.
On or before 7th of August 2026. Affidavit in opposition. Full stop. The petitioner would be further granted liberty to file affidavit in reply to those affidavit in opposition, additional affidavits in opposition on or before 14th of August 2026. This is the matter on 18th of August 2026. Final disposal.
Right.
Writ petition, the other writ petition, what to do? Let's see.
Obliged, sir.
The other writ petition goes taking into account the order passed in review petition number so and so, comma. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he will obtain instructions and file an application for withdrawal formally.
Obliged.
The same be done on or before the next. Review this post. I can restore it. Mr. Chaudhary, in view of the order passed in the review, categorically saying that the other aspects are closed, there would not be requirement of you filing an affidavit in the other matter, other aspect.
We will deal with only the new matter.
Only this. Others. And you file a formal application.
That matter where the appointment on on the same day from a different selection process, we were appointed in the earlier selection process, and the respondents were appointed in the later selection process. The High Court has filed its the respondent 4 and 5 has filed its affidavit, and we have also
Yes, High Court filed affidavit.
Yes,
Yes,
on
Lordship.
16/6.
You filed reply.
A reply to Lordship, yesterday only notarized. Today we have given all the copies. Now within one, it will be filed.
Okay. It has been submitted by Mr. B.P. Bora, the learned counsel appearing on behalf of the petitioner, that the affidavit in reply is going to be filed today.
Today, Lordship, copies given.
Such as the advance copies have already been furnished to the respective counsel. List this matter on 13th of August 2026.
Deeply
The registry shall bring on record the said
Deeply.
affidavit in reply.
Item 20.
We'll be filing it today.
Yes, Lordship, now only by one.
What is this?
Your Lordship, this is an illegal, arbitrary, and willful, deliberate, non-compliance of order dated 16 to 24. The impugn order is at page number 87, Lordship. Nice one. The government machinery is supposed to be giving instructions, Lordship.
Okay, why no steps? Have you referred it?
Lordship,
No reference has been made till yet, Lordship.
Lordship, I have not received the instruction. You communicated lot of time, Lordship, not received any instruction till today, Lordship. DC Kamrup.
I think we have the DC Kamrup present. This is not done. What is wrong with your
These
DC?
are our communications, Lordship. We have tried.
No, what is wrong with your DC out here? Does he think that he is above everybody?
These are the communications we have made, Lordship.
But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S.S. Government Advocate 2, 3, and 4. Respondent number 2, 3, and 4. It is the opinion of the Mr. S.S. Roy, the learned counsel, learned government advocate, has placed before this court that in spite of the order passed by this court on 31/3/2026, instructions from the District Commissioner, Kamrup Metro, the said officer, for reasons best known, have not provided information, instructions. This court have duly taken note of that, that the district commissioner taken note of that the instructions which have been sought for is in reference to a direction already passed by this court in the order dated 16/2/2024 in WPC number 8219/2019. The inaction on the part of the District Commissioner, Kamrup Metro, apparently shows that the District Commissioner, Kamrup Metro, the said incumbent District Commissioner, Kamrup Metro, appears to is not interested in the not interested to take steps is not interested to comply with is not interested and in the inaction on the part of the district commissioner Kamrup Metro the inaction on the part of the incumbent holding the post of the district commissioner Kamrup Metro in not providing the instructions shows a very sorry state of affairs. This court have also taken note of that whenever the learned government councils seeks for instructions, the district commissioners of the concerned districts appears to be not providing the information. The state executive, the executive, it is therefore the opinion of this court that it is high time that the state officials, state should take up due action as the inaction on the part of the district commissioners of various districts, including the Kamrup Metro, affects in the administration of justice. The Chief Secretary, the government of Assam, is directed to provide the Chief Secretary, government of Assam, is directed to place the Chief Secretary, government of Assam. It is the opinion of this court that the Chief Secretary of the government of Assam and the Advocate General of the government of Assam and the learned Advocate General of the government of Assam is required to take effective steps, is required to hold due consultations so that when instructions are being sought for by the learned government advocates, the district commissioners of the various districts responds and provides due information, instructions. List this matter again. On 3rd of August 2026, the Chief Secretary of the government of Assam is directed to apprise this court by way of an affidavit as to what steps in that regard have been taken so that the district administrations duly provide inputs to the learned government advocates. it is observed that if no inputs are being provided by the chief secretary, then in that case, this court would be compelled to require the attendance of the concerned district commissioners in each and every case, which may not be fruitful in the administration of which may not be directing the district commissioner to appear in each and every case in person, which may not be in the interest of administrative convenience. I think that is enough. A copy of this order is served upon the senior government advocate so that Government of Assam to upon Mr. D. Nath, the senior government advocate, Government of Assam, so that the order can be communicated to the Chief Secretary, Government of Assam, as well as to the Learned Advocate General. You need to, I think, your district administrations, they don't give any heed to the government advocates. It's high time. So I think in each and every case, we ask the district commissioners to be present in the court. That thing worked out with the GMC. Now GMC, we get the instructions for tweet. So this is not going to happen unless, therefore I have to involve the chief secretary. He has to take up it up because we have to, because if he is not providing information, what to do?
Communicated, the Lordship has seen.
Yeah, I've seen it. You keep this on record. We'll see it on the next day. Yes, what is this?
May it please your lordship. I'm challenging the order, my lord, dated 24/3/2023 at page 111, my lord. On the ground that is prior to his passing of this order, my lord, so cause notice was not served to the petitioner, my lord.
So cause notice.
I have not received, my lord. Ma'am, there were two proceedings, my lord. One so cause they have issued on 30/12/2020, which I received. I filed my reply, my lord. They have not decided till date. Then the pending adjudication of the so cause notice, I received another order, my lord.
So cause you received?
At page 95, my lord. For the prior period, my lord.
This demand comes so cause notice.
This I have received, my lord, and I have duly replied my so cause reply, my lord.
This is for the period.
This is, my lord. My lord, 14/15 and 15/16. That your lordship will find at page 101, my lord. Page, my lord, 101. Period is mentioned. Pertains to, my lord, 15/16, my lord.
In 16.
Yes, my lord. This I have received, my lord.
Here it says relating to this from October to March FY 14-15 to 2015-16.
My lord.
So 2015 means till 31st of March 2016,
my lord.
So it starts from October to now where's the impugn order?
My lord, lordship will, that your lordship will
For 16-17.
16/17, the impugn order, lordship will find at page 111. This so-called notice was for the financial year, my lord, 14-15 and 15-16 that I have received. I have submitted my reply, my lord. Thereafter, my lord, pending adjudication of this so-called notice, I received in order in original that your lordship will find it page 111. That pertains to subsequent financial year.
When did you receive it? Receive it.
The order I received on 13th April 2023, my lord. 13th of April, 13th of April, my lord. I made a statement, my lord.
How?
In paragraph 10, I have made a statement. In paragraph 10, I have made a statement. This order in original was received. It was, my lord, by speed post.
And what do they say? Notice about the notice?
The order in original does not contain any finding of service of this so-called notice.
Proposed notice is of dated 7/10/2021.
My lord.
What was the earliest so-called notice date?
That was, my lord, dated 30/12/2020, my lord. Page 95.
This is done under what provision?
Section 73 of the Finance Act 1994, my lord.
What do they say about in the reply?
My lord, they have in paragraph 12 of the affidavit in opposition, they have said they have sent it by speed post, my lord. I have denied it, my lord.
Has the notice been served to speed post?
Lordship.
Has the notice been served when you have sent it by speed post?
Actually, in paragraph 13 of our affidavit, Lordship it is stated that the notice was sent through speed post, but it was never returned to the department.
Okay, my good. You have said that it has been sent through speed post.
Lordship.
You find it out through tracking and all whether it was speed post.
So that to that effect there is no finding.
Then
But in paragraph 13 of the paragraph 14 of the order in original, page 119.
one
119, paragraph 14. However, there is no finding with regard to service of the notice.
he did not appear on that date also.
Yes, Lordship.
So what do your records show?
Lordship, we file affidavit, Lordship. Record is not available with me, but we file affidavit in this case.
So what is the procedure to be followed?
Lordship, if the petitioner doesn't appear, then the authority has to.
Regards service of notice,
Lordship, regarding service notice, Lordship, proof is to be, proof of service is to be, finding must be there. But that finding is not there. But it is stated that only the notice was sent. And in affidavit, we have stated that notice was sent through speed post. That was never returned to the petitioner thereafter. Lordship, many occasions, Lordship, opportunity was given to the petitioner.
and what is the period of limitation here?
5 years. From the date of my lord, due date of filing of return, my lord.
The due date of filing of. We are concerned with 16-17.
Yes, my lord, 16-17, my lord.
2016-17.
My lord.
What is the due date for filing return?
I'm giving, my lord.
You will go as per the CGST Act.
No, my lord, Finance Act 1994.
So what is the due date for, what is the due date for filing of the return? We are concerned with which years?
16-17 financial year, my lord.
16-17.
My lord.
Service tax.
Collecting of return is in section 70.
Furnishing of section 70. Every person liable to pay the service tax shall access the tax due on the service provided by him who shall furnish the superintendent return so form and in such manner and such frequency and for furnishing him. The period the person so and so shall furnish the return in such manner and in such frequency as may be prescribed. The prescription is where?
Rule 7, my lord.
Rule 7.
Service tax rules 1994, my lord. It says, my lord.
Service tax.
Rules 1994, my lord.
Rule 7.
Rule 7, my lord. It's my 25th day of the following month, my lord, of the half year.
Assessing the half yearly return in ST3 or STL as the case may be, along with a copy of the STL in triplicate for the months in the half year. Submit the half yearly return by 25th of the month following the particular half year. Means half year would be provided further the ST for the period from 1st of July 2012 to 31st of year shall be submitted by year by month. So here the filing of the return is half yearly.
Half yearly, my lord.
Or what is 3A, notwithstanding anything contained? Notwithstanding anything contained in sub-rule 1, every assessee shall submit an annual return for the financial year to which the return relates in such form and manner as may be specified in the notification year by the demand by the 30th of November of the succeeding financial year. Meaning thereby you are to file it by 30th of 2017.
My lord.
Yes.
Okay. And the order has to be passed within?
In normal course, my lord, within 1 year, my lord.
Where?
Section 73 4B.
E. 4B.
Section 70 is the subsection.
Shall determine the amount of service tax due under subsection 2 in 6 months from the date of the notice where it is possible. So in respect of the case falling under subsection 1 within 1 year from the date of notice where it is possible to do so in respect of the cases falling under the proviso to subsection 1 or to subsection 4A shall not apply in respect to so and so. So, shall determine the amount. Where is the limitation period?
It is now section 73, my lord. There are two types of period, my lord. One is normal period, that is 2.5 month, 2.5 year, and extended period is 5 years, my lord.
Huh?
Section 73, my lord, that provides, my lord, limitation, my lord. Section 73, subsection 1 provides normal period of limitation. It's, my lord,
Fraud, if it is a fraud, it is 5 years.
5 years. Otherwise, 2.5 years, my lord.
A person chargeable to service tax or his agent so and so shall have the, as if the words 30 months, the word 5 years have been substituted. 73(1), so it is 5 years.
5 years, my lord.
5 years from when?
My lord, either due date or, my lord, date of payment. It will lordship will find, my lord. Due date.
From the relevant date. Levied also a refund date. The
Subsection 6, my lord.
May within 30 months. 30 months will become 5 years. From the relevant date, serve notice on the service chargeable with service tax which had not been levied or so and so provided. So the period is 5 years.
My lord.
Within 5 years, the notice has to be issued.
My lord.
And within 6 months,
6 months or 1 year, my lord. There are two.
from the date of the notice where it is possible to, in respect of cases falling under subsection 1. your 4A is what? 4A is omitted. So it is 6 months. So the notice has to be issued within 5 years. And within issuance of these 5 years, the notice has been issued, the reply has to be finished up by 6 months.
6 months, my lord.
Isn't it? Now, if that be so, how is this order maintainable? Forget about him receiving notice or not. How do you take care of it? Because here the notice was issued in 2021.
Yes, sir.
The reply was given, the order was passed in the year 2023.
23.
How is it possible?
If this issue is issue, whether final order should be or the extended period, that issue is pending before the Honorable Supreme Court.
Which one?
The order beyond 1 year. Because here it is provided that the order should be passed within a year.
No. Mr. Kyle, you are aware whether the matter is pending before the Supreme Court hardly matters to this court. So don't make that type of submissions before me. My question is out here, when the order which was as per the act had to be passed within, the notice has to be issued within 6 months, 5 months, 5 years.
In 5 years. If there is a
5 years. Now here 2016-17, he is required to submit his return by 30th of November 2017. He has to issue the notice within 5 years from the death date, means on or before 30th of November 2022, he had to issue the notice. Now, in the instant case, notice was issued in the year 2021. That's well within time.
Yes.
But how do you take care of 4B?
probably that is not mandatory.
What?
Within 1 year, passing of the order from the date of
The
submission.
centralist shall determine the amount of service tax due under subsection 2 within 6 months from the date of the notice, where it is possible to do so in respect of cases falling under subsection 1. Where is it possible to do so? So we go on the question where it is possible to do so.
Yes.
So it is not mandatory. Unlike you have the provision of 7310, 9 and 74:9. So that period is when is it possible to do so?
Yes, sir.
So it is not fixed. Therefore, we interfere with this order. Relevant date means in the case of taxable service in respect of which service they have not been paid or so and so, or where was made under chapter periodical return, the returns of so and so. So in case where service tax is provisionally, in cases where so if we interfere with this impugn order, I have to date back this order to a particular date. When? So the period during which has to be excluded from the date of issuance of the notice becomes okay. The notice from the date of the notice till date be excluded so that he can file his return. That is the only way out, isn't it? Now, where is the notice issuance of notice requirement?
Section 73 is my lord itself. It says notice.
To show cause, 73(1).
One, my lord.
So it is case under 73(1), it's a case of fraud? No.
No.
No, because it was with, notice was issued within 3 years.
Huh?
Notice was issued within within a time.
So then it is 30 months,
30 months.
2.5 years.
2.5 years, my lord.
It will be construed to be 2.5 years.
2.5 years. But my lord, it is,
Are you sure?
no, my lord, it is, they have,
If it is 2.5 years within, then would it be within the jurisdiction to issue the notice in the year 2021?
it is issued under a proviso, my lord. That lordship will find it page 118, my lord. Page 118 of the order, they have quoted the part of the so-called notice.
Yes. Where?
Paragraph 13, my lord. Subpara A, my lord. Last 2 lines, my lord. Last 3 lines.
Subpara?
Subpara A, my lord. 13A, last 3 lines, my
Not
lord.
be demanded recovered from them under the proviso to subsection demand. So therefore they are doing it as per the proviso.
Proviso.
Which means it's a case of fraud.
Fraud. 5 years.
A case of fraud. Not under subsection.
No.
Hello? Does dictate. Heard Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner. Mr. Mikhail, the learned senior counsel, who is the standing counsel, the CGST department. Assisted by so-and-so appears on behalf of the respondent numbers of
2, 3, and 4.
The present petition has been filed by the petitioner challenging the order in original bearing number 26/JC/ADJ/ST/BIB/2022-23. Hereinafter referred dated 24/3/2023. Referred to as the impugned order solely on the ground that the said impugned order was passed by the respondent number
3, my lord.
3.
3.
3. Without issuance of notice as is mandatorily required under section 73(1) of the Finance Act 1994. First. The petitioner herein is a partnership firm registered having registered under the provisions of the Indian Partnership Act 1932. Are you? No.
No, madam. No, madam.
Is a partnership firm which is registered under the Service Tax, which was registered under the Service Tax Act,
My lord.
the Finance Act 1994,
My lord.
was issued a registration number.
My lord. ADCFS, page 112, my lord.
Eh?
Page 112, my lord.
Registration number.
Fifth line, my lord.
Hearing service tax registration number ADCFS 7829 LSD 001. Pustup. It is the case of the petitioner that on 13/4/2013,
13/4, my lord.
on 13/4/2023,
My lord.
the petitioner was served with the impugned order whereby an amount of rupees 1,27,71,113 have been demanded as the service tax for the period for the financial year 2016-17 under subsection 2 of section 73 of the Finance Act 1994. In addition to that, interest terms with section 75 and read with section 175 of the Finance Act 1994, read with section 174 of the Central Goods and Service Tax Act 2017 was also imposed. The petitioner was also imposed a penalty equal to the amount of service tax so demanded under section 78 of the Finance Act 1994, with an option to pay 25% of the penalty imposed if the said payment, if the entire amount of the service tax demanded along with the interest was paid within a period of 30 days from the date of communication of the impugned order. In addition to that, the petitioner will impose other penalties of rupees 11,600 and rupees 40,000 under the relevant provisions, section 77 and section 70 of the Finance Act 1994, respectively. Next. The sole basis on which the present petition has been filed is that the said impugned order was passed behind the back of the petitioner and without issuance of the show cause notice as is required under section 71 of the Finance Act 1994. This court duly takes note of that when the writ petition was filed before this court on duly takes note of that by an order dated 26/3/2023, the learned coordinate bench of this court, while issuing notice, categorically observed that no coercive action shall be taken against the petitioner. The records reveal that the respondents have filed the affidavit in opposition. In the said affidavit in opposition, the respondents have categorically stated various aspects on the question of merits. But taking into consideration that the sole ground on which the present writ petition has been filed is in respect to non-service of notice under section 73(1) of the Finance Act 1994, it is relevant to take note of paragraph number 12 of the said affidavit in opposition, wherein it is mentioned that the so-called notice dated 7/10/2021 was issued to the petitioner and was served through speed post bearing consignment number ES 8825824009 IN. However, it is relevant to take note of that though it is mentioned that the service of the so-called notice was made through speed post, neither the consignment, neither the tracking information that the service was affected, service of the so-called notice have been affected, have been mentioned, have been placed before this court. The records also pertaining to the postal receipt as well as the acknowledgement, if any, by the petitioner have not been placed. This court also duly takes note of the affidavit in reply filed by the petitioner, wherein at paragraph number 11, the said aspect of the matter have been duly denied, by stating inter alia that that the said show-cause notice was not received. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on board. A perusal of section 73(1) of the Finance Act 1993 is a provision relating to recovery of service tax not levied or paid or short paid or short levied or short paid or erroneously refunded. In terms with subsection 1 of section 73, it is mentioned that it is stipulated that where any service tax had not been levied or paid or has been short levied or short paid or erroneously refunded, the Central Excise Officer may within 30 months from the relevant date serve notice on the person chargeable with service tax which have not been levied or paid or which have been short levied or short paid, or the person to whom such tax refunded has been erroneously being made, requiring him to show cause why the person, the noticee, should not pay the amount specified in the notice. The first proviso to subsection 1 of section 73 stipulates that in the cases falling in the cases in respect to cases where any service tax have not been levied or paid or has been short levied or short paid or erroneously refunded by reason of fraud or collusion or willful misstatement or suppression of facts or contravention of any of the provisions of chapter Roman 5 of the of chapter Roman 5 or the Roman 5 of the Finance Act 1994 or the rules made therein under with an intent to evade payment of service tax by the person chargeable with service tax or his agent, the provisions of subsection shall have effect as if the words 30 months, which have been mentioned in the main subsection 1 of section 73, shall stand substituted by the words 5 years. In other words, in the case where service tax has not been levied or paid, or has been short levied or short paid, or erroneously refunded by reason of fraud or collusion or willful misstatement or suppression of facts or contravention of any of the provisions of chapter Roman 5 or the rules made therein under with an intent to evade payment of service tax, the period of limitation for issuance of the notice is 5 years. In the instant case, it is also relevant to take note of the explanation to subsection 1 of section 73, which stipulates that where service of notice is stayed by an order of the court, the period of such stay shall be excluded in computing the aforesaid period of 30 months or 5 years as the case may be. In the instant case, as no proof of service of notice of the show cause notice dated
7/10/2021. 7/10/2021, my lord.
7/10/2021 would be placed before this court by the respondent authorities, comma, and it is the petitioner and it is the specific case of the petitioner that the petitioner had not received the show cause notice dated 7/10/2021 or any other correspondence thereafter as have been mentioned in the impugned order. Therefore, the opinion of this court that the impugned order cannot be sustained in law. Inasmuch as the impugned order has to be held, it cannot be sustained in law. Next. This court, however, also this court also finds it very pertinent to observe that from a perusal of the impugned order as well as the show cause notice. You have enclosed the show cause notice?
No, my lord.
Why haven't you not enclosed? I would have asked him to file his reply.
Dr. Provide will within a week will supply in the copy.
Yes, my lord.
Because then I could have counted from there, na? This court, however, finds it relevant to observe that in the instant case, the had also perused the impugned order. And from a perusal of the impugned order, it is the case of the respondents that that the petitioner is trying to escape for payment of service tax from their end by suppressing the material facts from the department with an intention to evade payment of service tax, and therefore have employed the first proviso to section 73(1) of the Finance Act 1994. Considering the above, considering that the so-called notice dated 7/10/2021 was issued to the petitioner but not served, was issued to the petitioner, bracket or the verb, but not served, bracket close. The said so-called notice was within the period of limitation as stipulated in the first proviso to section 73(1) of the Service Tax Act of the Finance Act 1994. It is therefore the opinion of this court that the period during which the period from the date of the said show-cause notice till date is required to be excluded in as much as it is the only case of the petitioner herein that that the petitioner was not provided with an opportunity by way of a show-cause notice to explain that the petitioner's case do not come within the ambit of initiation of a proceedings under section 73(1) of the Finance Act 1994. Accordingly, the instant writ petition stands disposed of with the following observations and directions. You don't have a copy of the Finance Act, so-called notice also.
So within a week, I'll ask my officer to supply copy of the petitioner. Within a week from today, supply copy of the notice to the petitioner. After he will, I'll reply and
the line neither placed any materials nor the so-called notice have also been enclosed to the present proceedings or produced before this court. Impugn order dated. The impugn order dated 24/3/2023 being in violation to the provisions of section 73(1) of the Finance Act 1994. Set aside and quash. Number 2. Period. Also, number 2. The setting aside and quashing of the impugn order dated 24/3/2023 by this court shall not preclude the Central Excise Officer, the proper officer or the Central Excise? Central Excise. The Central Excise Officer to issue a fresh notice to the petitioner, show-cause notice to the petitioner, thereby granting him an opportunity to show cause if proceedings are initiated under sections are proposed to be initiated under section 73(1) 1, and the proviso, the first proviso to section 73(1), under section 73(1), or the first proviso to subsection 73(1) of section 73(1) of the Finance Act 1994. Also, number 3. The period from Seven 10/2021 till date be excluded while computing the period of limitation for the purpose of taking steps in terms with section 73(1) read with section 73(4)(b) 4B madam, of the Finance Act 1994.
M25, fixed at 2 p.m.
To your people. Otherwise, tomorrow, if you don't send it,
today itself.
again, it will be kept it out there, and then the period, now your period is 30th of Ivan, you have to issue your notice. Issued it on 7/8. 7/8, na? When was the so-called notice issued?
710 is issued on.
7/10, 2011, and it
21.
was already 4 years. So 1 year almost is there.
Immediately we'll issue. In a week. Much more.
Lordship. Lordship was pleased to fix this matter for final disposal today, yesterday, Your Lordship, but I couldn't find, before submitting the facts of the case, Your Lordship, I couldn't find the affidavit in reply today also because the deponent, the writ petitioner is out of station and he's having some infection in his eyes, so he couldn't travel from there to sign the affidavit.
Argue on this.
Lordship.
Argue on the materials which are available.
Lordship. By of this writ petition, I have challenged the debarment notice whereby I was blacklisted to participate in any tender process in the respondent company, that is Telecommunications Consultants India Limited, which is a central body, Your Lordship, at page 38, Your Lordship.
38.
38, Annexer 8.
Rejection of the bid and banning of business with
The petitioner. Lordship. Lordship, the allegation.
so-called notice.
There was a show cause notice, Your Lordship, and I have given a reply also.
The so-called notice.
Yes, Your Lordship. The show cause notice at page 33, Your Lordship. This is the show cause notice, 15/12/2021, Your Lordship.
This is reference to Iman, referred to Iman tender.
And I have given my reply at next page, page 35, Your Lordship. Regarding the completion certificate.
So you say that these completion certificates were without letter number and year.
Yes, yes, Your
And as such not maintained.
No, that is what is my, the fact of the case,
My question is,
yes,
let's see your completion.
page 221. In the affidavit in opposition, page 221. As of now, I have all the documents to show that I have completed the work.
I'm not there.
As on that day, this is the only document I had, 221.
Date also.
221.
Completion certificates are without date also.
Yes, Your Lordship. This actually what happened, since I had to participate and I had completed the work, only the tendering authority, that is the superintending engineer, I requested him and he gave a certificate in the pad with the official seal. But these are not numbered. Subsequently, when they do all the formalities, law books and everything, they prepare the actual completion certificate, which they have handed over later on, which I have presently. Not before Your Lordship, but I can submit those documents. All the things, my bill, running bill, current final bill, everything is there. So it is
You
a
have the
fact that I have completed this.
You have the completion certificate.
As of today, I don't have.
Why do you say that you have?
I have, Your Lordship. As per the instruction of my client, all the final bills and
When did
everything.
you complete this work?
The final bills are also there.
I'm asking you, when did you complete this work?
That was completed before 2022, Your Lordship. Before 2020, when the certificate was issued, before I participated in the tender process.
This certificate has no date.
That is the thing, Your Lordship. Because this is solely, I have informed him, the concerned officer, that I need to participate. So since I have completed, kindly issue.
Are you a first time bidder?
No, Your Lordship. I have other documents to show my credentials.
First time bidder? No.
No.
You know
definitely
this
not.
type of certificate is that. This is on the face of it, it appears to be a fake certificate.
But the fact is that I have completed this work. That I can show, Your Lordship. I have received the entire bill for this work. And this is not the only work I have done under NHM. I have done several other works also.
I am concerned with these two documents. Did you provide those documents? Then what happened?
Thereafter, I submitted my show-cause reply, Your Lordship. And this is their case in their affidavit of opposition. They have stated.
36.
Yes.
It's 36.
Page 35, I have given the reply.
It
And
says
then
we
I
have
was
to
not
pay
aware
the
that they have.
terms and so, ending in the negative list of any department or failure to follow. What is this? Termination of contract?
Lordship, yes. This is how I came to know about my debarment, Your Lordship. I participated in another contract under Assam Police Housing Corporation Limited. So there I had to furnish a affidavit swearing that I was never blacklisted. Since I was not aware that I was blacklisted by the respondent authority, I showed a affidavit that I was never blacklisted. Later on, they came to know that I was blacklisted by the respondent authority, and that is why they have terminated the other work also, where I participated under the state government. For the first time, I came to know that I was blacklisted. And after that, I filed this writ petition, Your Lordship. Now, in the affidavit in opposition, their stand is that they have never received the show-cause reply. That is why they have never given me an opportunity of being heard before passing the final order. That is their case, Your Lordship. But I have submitted my reply. And before all this, what happened, Your Lordship? If I may kindly submit about the facts of the case, Your Lordship. Just 1 minute, I'll take, Your Lordship, couple of minutes. And I am not the only one. They have devoured scores of other bidders also, for one reason or another.
You do one thing. The council, you are appearing for who?
My lords, I'm appearing for the respondent in this matter, TCIL.
You do one thing. We interfere with this order, give him an opportunity of hearing and then pass an order.
Lordship.
My lords, if I may, my lords, his whole contention is that the blacklisting order, he was never aware. My lords, I can show from my affidavit for opposition
Let us assume that
that,
he's no, let us assume that he's aware. You are for TCIL, na?
Lordship.
my lords, I am from TCIL. I am for TCIL.
He's for his basic contention is that I have never been heard.
Lordship.
And he has submitted the show cause.
My lords, but however, he has not filed any documents to show whether that document was filed or not. Because, my lords, all my letters are filed with a proper email showing that service was done. However, if my lords see that letter which he is relying upon that it was served, saying that I gave the service, my lords will see there is no tracking report or any email to show that whether it was delivered to me or not.
Before this, I have submitted another letter, and they have
My
never
lords,
said that they have
this
not received
is
it. For
this
the
is all
other letter also, I
hearsay.
don't have any track report.
Oh, how did you submit this document?
Your Lordship, I've submitted this document by way of post, Your Lordship.
Post.
Yes, Your Lordship.
Postal receipt.
There is no postal. I've asked my client, it's long back.
There is no postal receipt.
Postal.
Secondly, you see the address. The address at page 35 is without nothing.
No, this is because in the body of the letter just.
Where is your envelope?
Envelope that also the client is not.
You don't find any good ground.
But there is another letter, Your Lordship, I have annexed. They have admitted that they have received it. Similar kind of letter. This is not regarding the SOCO reply. Earlier, I have requested a.
Here, this document doesn't show that you have served.
I don't have any proof, Your Lordship.
Nothing out there. So we.
But it is an admitted fact that they have not given any opportunity of being heard, Your Lordship. That is they have admitted in their.
Obviously, when you don't reply, where is the hearing?
I had replied.
Hearing will come only when you ask for it. You have not asked for it.
I had
submitted this document.
I had submitted, Your Lordship.
No.
And one copy, even my client has stated that one copy when he was in Delhi, he has given by hand also. So twice they have been served.
Where's the receipt?
They don't give any receipt, Your Lordship. That is,
Tell me they don't give a receipt.
this is an organization. They don't have any receipt branch.
You tell me you got this document how? Got this document?
By mail. By mail.
By mail.
Yes, Your Lordship.
Then why on earth you did not reply on mail?
He's not, generally he's not.
That?
His employee looks after all this thing and he's not that much educated. So my client, Your Lordship.
He's not educated.
He is educated, Your Lordship, but generally he's not. No, but
Generally-
anyway, Your Lordship, I have submitted. That is, this is specifically I have pleaded, Your Lordship.
Okay. And it is on the face of it, it appears to be a fake.
Your Lordship, that I can submit the documents to show that I have received the final bill for this work.
So what?
It is a fact that I have.
Why on earth did you submit a document which is undated? On the face of it, that document, and why, and you would not have got a stay order if you have submitted this Annexer 7 series with your petition.
It was not available with me. That is another ground, Your Lordship. It
How?
was not available with me.
This is a document of certificate which you have placed it before them,
yes,
and you don't have a copy.
Submit the originals. That is why, Your Lordship.
You don't give a photocopy also.
Even my client couldn't give me the tender documents also. After they have submitted, I have found out, Your Lordship, all the tender documents and the clauses and everything. At the time of filing the writ petition, it was not with me, Your
Mr.
Lordship.
Sharma, I'm not saying about you.
Lordship,
I'm saying
Lordship,
about
I
your
understand.
client.
I understand, Your Lordship.
Your client
Could
doesn't
not
seem to be
furnish, could not
honest.
furnish on time.
Your client doesn't seem to be honest. These documents should have been a part of the writ petition.
Should have been. That is why I have asked from.
And he has
for
not
filing.
given it. He's not entitled to it.
Lordship, there are other things I can
There's
substantiate.
nothing else.
And regarding,
I'm satisfied.
they don't have the right
Remaining
to
it
forfeit
for,
the.
you have put 9 judges in division bench, they will look.
No, Your Lordship, only thing. The other grievance is that they have forfeited this security deposit. They don't have any right to do that. Even if I am blacklisted, then also they don't have any right to do that. Forfeiture of security deposit.
Why?
Because as per them, they have forfeited as per the integrity pact. Forfeited my security as per the integrity pact. Integrity pact is an agreement which I sign. They will sign later on after I get the work order. In the integrity pact, the clauses are for corruption. If I give bribe to any officials of TCIL, or if I use any influence from the government official or politician or any other influential persons, these are the grounds under which my security bid can be forfeited.
Let us see.
Yes, page
The
190.
document.
192, Your Lordship. This is the integrity pact.
No, forget about it. That it will be there.
Tender document forfeiture, in the impugned letter itself, the clauses are mentioned, Your Lordship.
No, not necessary. Here we will see in the tender document. Yes, Mr. Counsel, what is the date? What are the terms?
I'll take my lords to the term, my lords. My lord, there are a few integrity pact which my learned friend is referring to is at page, my lords, just a second, I just had the page number noted somewhere.
190.
190, my lords. No, not 190, my lords. It is there in my tender, my lords.
No. The forfeiture of the security deposit or the earnest money, na?
Yes.
Earnest money.
Earnest money will be there in in this thing, banning of business.
They are referring to clause 1.2, clause 2.9, and the integrity pact.
Do one thing.
And another aspect, after the affidavit of
For
opposition is
that,
filed,
you go
I
for
came to know, your
arbitration.
lordship, another aspect, that
For that you go for arbitration.
that the competent authority did not, the blacklisting order, that order was, impugn order was not issued by the competent authority.
That will, I'm not going to share with all.
And they have also not followed the procedure as per their own guidelines regarding blacklisting of a person, your lordship. And I can place Honorable Supreme Court judgment whereby this blacklisting is, they have to follow the entire procedure before blacklisting someone, your lordship. And also, as per guidelines, they cannot blacklist for me for more than 2 years, but they have blacklisted me for 5 years, your lordship. There are many other grounds also, your lordship.
Whereas my contract says that I have to blacklist them for 5 years, it's proportionate, my lords. I can show that. Page
5 years, it is not
158.
mentioned. It says
It's 5 years, minimum period of 5 years.
The clause says 140.9.
yes.
141, 2.9.
Yes, your lordship.
For a period to be decided by the employer.
Yes, that much only. And as per general financial rules, your lordship, it cannot be more than 2 years.
My lords, may I?
That general financial rules 2017, your lordship, issued 2017 issued by the Ministry of Finance Department. General Financial Rules 2017 issued by the Ministry of Finance, your lordship.
Ministry of
Department
Finance
Department
of
Central Government, your lordship.
Central Government.
Minus page 158 for sanctions of violation. Para 7 gives the how much minimum period I can blacklist him for. Roman 7. If my lords want, I can read that. Page 158 of my affidavit in opposition.
Now kindly come. Was 2.23.5. Page 144.
Two 2.23.4, your lordship. 0.5.
144.
Yes, these
So
are the two.
this security,
Yes.
this security can be done only under A and B.
Yes.
There's no other ground. There any other ground? Now, what do you say about page 158, 5, Roman 2?
Lordship, it is says it is should be forfeited, it says, my lords. If my lords have it, my lord, it says the earnest money deposit or security deposit shall stand forfeited either fully or partially as decided, and the buyer shall not be required to assign any reasons thereof.
This is for the purpose of the integrity pact.
Integrity pact. That is for corporate.
Integrity part.
Integrity
My
pact
lords,
is when? Now, therefore, to avoid forms of alia by transparent so and so. Now, when would the integrity pact come into it? Will have a year.
As per one of the
Whether misleading information would come within
No.
the ambit of a integrity.
no.
my lords, it is a forged certificate because my lords, NHM in his own reply has said that it was not issued by them. So, my lord, it is a forged certificate which has been issued, my lords. That is our case.
The force certificate also, would it come within the mischief of the integrity pact, by which?
My lords, that is my submission. It will come in there because it is the violation.
Don't make a submission. You have to show it from the integrity pact.
My lords,
Bribery will come. A case
Yes.
of corruption will come. But
Influence will
would
come.
a case of false or a fake certificate, would it? Show me that. I want that.
It's not there. I have read the integrity.
Commitment of the buyer.
And this is an integrity present agreement which will be effective only
Commitment of
after
the
both the
bidder.
parties sign.
Let's see 3. The bidder commits itself to take all necessary measures, even corrupt practices.
Unfair.
Unfair means an illegal activities during any stage of the year. So, fact or fact stage in year secure any man. The bidder shall not offer directly or intimate any bribe, gift, consideration, reward, favor, or a material, immaterial, or other advantage, commission, so and so. Undertakes that it has not given, offered, promised to give directly or indirectly any bribe, so material, any material or immaterial benefit or other advantage, broker. Foreign billers will disclose so and so. Bidders shall disclose the payment they have, shall confirm that declare to the buyer that the bidder has not individual or from where the Indian so and so is so and so. The bidder, while presenting the bid or during the swell, shall disclose any payment he has made in committed to or year, shall not feud with other parties, will not accept, not use improperly for use of competition or personal gain, so and so. Not pass any information here. As part of bidder commits to refrain from giving any complaint of any of the bidder or so and so. Bidder shall not lend any money from, shall not bring any political so and so. Illegal or illegal practice will undertake to demand from all
Judgment kitab.
any earning. This won't come here.
my lords.
This won't come here. How do you forfeit the bank area?
My lords, if my lords see that we have forfeited because my lords, as per the integrity pact, I showed my lords that we can do that. However, my lords, one more thing in my
You can do as per the integrity pact. There's no quarrel with that proposition. You can very well do as per, but provided these are the infractions.
So, my lords, if the
A
my
false
lords,
event does not fall within the ambit of a fake document. Must be somewhere. When did you complete your work?
Completion was done before I participated in the tender process. That
When
much
did you
sure. But the final
participate?
bill I have received on the later stage.
When did you participate? You must have received the completion certificate.
I must have. I have received the bill. That much I can submit before your
I'm
lordship.
not extending the
That-
interim order. I'm granting you an adjourn by that. So that the moment you are making that submission, we are going to take an action against. Yeah, because you have made a statement before this court. Then I will take it against you.
regarding receipt of bill, I have
No, I'm not on that. That you have completed
that I'll have to inquire.
prior to 6/1/2022, you have completed. I'm going to take a very stringent action, Mr. Sharma.
Lordship. That much instruction I have.
Against you there. And I'm going to take it against
I
you.
understand, your lordship. I have received the
Not going
bill
to
that
I'm not going to extend. This is apparently the court should not have granted you any stay or anything. Order is absolutely only as regards forfeiture of bank the security deposit. I'm not satisfied with what the respondent counsel said.
my lords, in this regard, I may say there is a arbitration clause because it's a commercial contract, my lords. So against forfeiture, he can invoke the arbitration clause. That is very well there, my lords. Also, there is
The first of all, if you cannot show to me that about the forfeit, that if a fake document, if it is submitted, to come within the ambit of a forfeiture. Integrity pack, if it doesn't involve the integrity pack, then you have to go to 223.5. 223.5 does not empower you to do that. It will only
I understand what is falling from my lords. I understand that.
because I'm not going to allow this person from here to go there again for 10 lakhs. Much.
10 lakhs.
10 lakhs. But anyways, for going for arbitration, why should we have on a space?
So, my lords will pass any order, we will comply with that order. To that extent, my lords,
You cannot forfeit that amount, but the fact will be the year is okay. But if it does not violate the integrity pact, then what do you say about those two judgments wherein that 5 years too long a period, 2-3 years? Period.
my lords, as per my contract, the minimum period is 5 years.
Where?
My lords, it is an integrity pact. I'll show to my lords, page 1.
No, Mr. Counsel, the problem lies there. If you can't invoke the integrity pact, then 5 years does not come into the signal.
So, my lords, if
you can have to go back to the terms of the contract.
no, my lords, I totally understand.
Categorically says that as per what can be desired by the employer.
My
Now,
lords.
if you want to do so, you have to give reasons for that. That is one way out. Or secondly, I give you an opportunity now again to decide.
My lords, may I take instructions on this? My lords, may I have it tomorrow?
The reason is then you can very well modify and do whatever things you want to do with him.
My lords, may I have it tomorrow? I will take instructions on both the aspects, my lords. At 2 p.m., I'll take instructions, my lords.
No, not tomorrow. We'll have it on next Tuesday. I'm not going to extend it.
Lordship, I've just received the instruction that I can give all the documents to show that I have completed the work.
When?
1 week time maybe.
When did you complete?
That actually
that is the only thing, because this document was issued on 6/1/2022.
Yes. Before that, I must have completed.
The reply.
Lordship.
This document you have issued most probably must have given in the year 2021. And in the year 2021, did you complete the work? The question is there.
Lordship, I understand.
So
I understand.
therefore, the document is absolutely on the fake side.
If I have completed the work at the later
Mr.
stage, then
Sharma,
I
I
have
have
submitted
to
a
be
fake document.
convinced to extend an interim order. Yesterday, I did it because we didn't have the time to take it up today. So
Lordship.
now I am not satisfied for extension of this. But the question is of forfeiture. We are looking into it. We'll take it up tomorrow on next Tuesday. But I'm not going to extend the interim order. I'm passing an order why I'm not extending it. In the meantime, if you file a reply,
I'll file a reply.
you file your reply. But I'm not going to extend it. Let me come back in 5 minutes.
Okay. Can I pray one thing? I'll submit all the documents that I understand what your lordship requires, your lordship. Within a week. Next Friday, your lordship, only 1 week may be given. Till then, interim may be continued. Your lordship,
Sorry.
this 5 years is going to anyway.
It is absolutely, the court should not have passed the order.
I understand, your lordship.
Extend the period only. We have done.
And your lordship.
In these type of things, this is what your client has done. All.
Let him also take instruction, your lordship, regarding the earnest money thing, and I'll also file all the documents, your lordship. If thereafter your lordship is not satisfied, your lordship may dismiss it may be kept as part heard, your lordship.
My lord, documents cannot be
One-
filed at this stage because, my lords, I was only given the work experience certificate against which I verified that, and which was said to be not to be issued. So if he files a final bills also, lordship, right, it won't be of any effect. That is my humble submission.
No.
My
There is
lords,
one regarding this, I have to say, there is one contention from their side in the affidavit of opposition that for the same work, some other bidder has also given the work experience certificate for the same work. Now, the same work cannot be done by the two contractors. I can satisfy your lordship that I have completed the work.
You have not given your certificate. When you filed the writ petition, why haven't you enclosed the certificate?
No, it was.
Why haven't you enclosed this? The court was much, the learned coordinate bench was very, they had passed this order. This court should not have.
I must admit, your lordship, while filing the writ petition, I have very limited documents, your lordship, to
Why?
produce, your lordship. That is one thing, your lordship.
You had the
Now also till
certificate.
date also they are not.
You had the completion certificate.
I have the proof of
You
bill.
had the completion.
I have the proof of bill being made.
No, Mr. Counsel. See, 2022 was the date. On 6/1/2022, the document which you say that you have you submitted a document saying that you have completed the work.
And
Did
I
you
don't.
quarrel with that proposition?
No.
In the year 2024, are you saying when you got that order and you filed the writ petition on 14/5, after 2 months thereafter, you did not have the completion certificate at that point of time? Then it is something very serious. You are there for NHM. You are appearing for NHM a party? No,
No, it's not
NHM
a
also you have not made a party.
Because I am aggrieved only by the.
No, it is the NHM who have issued the letter to you saying that this is a fake document. NHM has said that this is a fake document.
Lordship.
Then, to him the affidavit filed by the respondents. Mr. Gogoi, you are a standing counsel of NHM. Kindly see this document, page 221. This is the document which NHM says that this is a fake document. Kindly see page 221. 221. We get from you the instruction about this thing also. Not extending it, this type of orders.
Then it's the manufacturer document, man.
That is why they have blacklisted him.
Yes.
Now, this document He has not enclosed with the writ petition. He filed the writ petition on 14/5/2024. On 6/1/2022, when he submitted this, he said, he gives a reply. He says that he has given a reply. As on that date also, the work must not have been completed. So obviously, it is a fake document.
In the year 2023, that much I know. In the year 2023, I have received the bill, final bill. That much.
I'm not on the final bill. I'm on the question that as on 6/1/2022, which is your document of reference.
Whether I have completed the work or not.
Can these type of certificates be given NHM?
Oh, in fact, my lord, the letter pad also manufactured.
See this? That he has completed this 100-bedded work of so and so. NHM says that this work was done by somebody else.
No. That is not. It's not said. They have not said that. They have only said that this was not issued from the office.
Isn't it, Mr. Roy?
My lords, it is saying that it was not issued by their office. It is written that with reference to the abomination, it is to inform you that completion certificate enclosed along with the letter and the reference were not issued by this office. P correction 8, page 223, my lords. So, my lords, I will be going with that letter only, na, that he has submitted a false certificate.
Wait, I'll ask the standing counsel of the NHM, get an instruction as to whether, when was this work, whether it was done by the petitioner, and secondly, whether the work was completed by the petitioner as on 6/1/2022. That is the document of reference. Because he has taken this order, because then we will not only take action, we will also say that you have submitted a fake document before this court also. Heard Mr. P.K. Sharma, the learned counsel, appearing on behalf of the petitioner. He appears on behalf of the respondent. The present writ petition has been filed by the petitioner, assailing the communication dated 24/3/2022, issued by the respondent, whereby the petitioner was banned from participating in any business activity with the respondent / the TCIL for a period of 5 years from the date of issuance of the banning order dated 29/3. From the date of issuance of the order dated date of issuance of the banning order dated 29/3/2022 for all items / works / services the reason it is taken note of that the said order dated 24/3/2022 apparently was preceded by a notice
Dated 15/12/2021, page 33.
dated 15/12/2021, wherein it is entirely mentioned that the petitioner had submitted completion certificates in respect of 2 works issued by the Office of the Mission Director, National Health Mission, Assam. The 2 works were A and B, page 33, Pabo, A and B. In the said show cause notice, it was further mentioned that when The respondent sought for verification from the National Health Mission. It was categorically mentioned that the completion certificate had not been issued by the National Health Mission. Under such circumstances, the petitioner was show cause as to why action should not be taken under clause 1.7 bracket certification of genuineness bracket close, comma, clause 2.9 bracket debarment oblique blacklisting of the bid document, and clause 5 of the Integrity Pact bracket sanctions for violation. The petitioner claims that the petitioner had submitted a reply on 6/1/2022. However, there is neither any materials to show that the said reply was at all submitted to the respondent. Subsequent thereto, on 24/3/2022, the petitioner's bid was not only rejected, but the petitioner was also banned from of business dealing with, and there was a blacklisting of the petitioner for a period of 5 years from the date of issuance of the said order. This order dated 24/3/2022 have been put to challenge by filing the present writ petition on 14/5/2024. The records reveal that this court, by an order dated 25/2024, while issuing notice, directed that till the next date, the order dated 24/3/2024, bracket sick, 24/3/2022, bracket close, shall not be given effect to. The records further reveal that in the meantime, the respondent has filed an affidavit in opposition wherein the tender documents, the guidelines of the respondent on banning of business dealings, the certificate which were submitted by the petitioner, and the reply of the National Health Mission Assam have been enclosed. The reply was filed by the respondent as far back as on 22/11/2024. though on various occasions, time have been sought for. No affidavit in reply have been filed by the petitioner. This could have perused the materials and record. Well, Mr. P.K. Sharma, learned counsel, submits that on account of the urgency in submission of the bid, these certificates, which have been enclosed as Annexure 7 series to the affidavit in opposition, have been issued and were submitted by the petitioner. This court have duly perused the said certificates which have been enclosed as Annexure 7 series, and it surprises this court that the said certificates do not bear any date or official seal. This court, during the course of the hearing, inquired with Mr. P.K. Sharma, the learned counsel, as to whether the petitioner have completed the work and when. No answer to that regard could be provided. In that regard, Mr. P.K. Sharma, the learned counsel, submits that the petitioner would like to file a reply. Taking into account that these are certificates issued by the National Health Mission, Assam, this court have requested Mr. B. Gogoi, the learned standing counsel of the National Health Mission, Assam, to provide inputs pertaining to the veracity of these two certificates, which have been enclosed as Annexure 7 series to the affidavit filed by the respondent, and also as to when and as to whether the work in question was at all awarded to the petitioner, and if so, when the work was completed. Taking into account the above, it is the opinion of this court that the interim order cannot be allowed to be continued, inasmuch as continuation of the interim order would be an abuse of the process of the court. This opinion of this court is based upon the fact that prima facie, it appears that the documents which were submitted by the petitioner were fake and forged documents. List this matter again on 11th of August 2026 at 2 p.m. for further hearing. The name of Mr. P. The registry shall show the name of Mr. B. Gogoi, the learned standing counsel of the National Health Mission in the cause list. Photocopies of the registry shall also provide photocopies of page 221 and 222, which is Annexure 7 series, to Mr. B. Gogoi, the learned standing counsel. Pages 221, 222, and 223 of the affidavit in opposition filed by the respondent, so that he can obtain the necessary instructions and place before this court. In the meantime, the petitioner is also granted the liberty to file a reply if so advised on or before 5th of August 2026.
The integrity.
Post you
No,
want.
no, no, no. Your Lordship.
Grateful, my lords.
26, fixed at 2 p.m.
Yes, Lordship.
Somehow I can tolerate many things, but I can't tolerate one thing. This is a case of apparent misleading of the court.
Your Lordship, this
I'm telling you, you are trying to, you could have done it much better.
Lordship,
This is not
whatever
what we
documents
have
I had
expected.
furnished, Your Lordship, and
This is not
I
what
have
we
clear
expect.
instruction
This
that
is not
he-
what you do. You should have, at the first moment, you should have filed those two documents along with the petition.
I had asked, but there was urgency at that time because Assam State Housing, that police housing, they have rejected the bid. That is why actually the sole intention of filing the petition was that I wanted to participate in that Assam State Police Housing, Your Lordship.
Have you been rejected there?
I was rejected there, but my earnest money was, I was fortunate that they have returned the earnest money, that much
Should
only.
we direct the Assam police to again take back?
Otherwise, as a counsel, I was aware that these two documents are important.
These
but my
two
client
documents were must.
Yes, I am aware, Your Lordship.
It also leads to a suppression of material facts before the court. Anyways, on that next date, after getting information, we impose cost.
Lordship, but the sole intention of filing the petition to the
Whole intention was very poor. Very bad. Next.
May I please, Your Lordship?
Yes.
My lord, may kindly peruse page number 50, Your Lordship. Page number 50, my lord. This is the text in page 50, my annexure 6. My lord, this is the tax invoice, Your Lordship. I have paid the whole amount to the supplier, Your Lordship, including GST and other taxes.
This happened in. When did this happen?
My lord, the impugn order is at page 60, my lord. My lord, what happened in this case, Your Lordship? Earlier,
Impugn order, madam, at page?
page 60, Your Lordship. Annexure 9, my lord.
Rectification order.
Rectificate, because earlier
The
they have
application for rectification above has been examined and on the basis of your wherever the accuser got the nexus when so. So. When likely to make payment by so and so, you wish to see.
my lord. Earlier, they have issued another show cause notice, Your Lordship, of amount of rupees 4 lakhs. Thereafter, I have replied, Your Lordship. After reply, they have ratified that amount and reduced that amount to 1,60,000. Now, 1,60,000, Your Lordship. This rectification order. Now, in this, my lord order, my lord, page number, page 50 is the index, Your Lordship. I am the purchaser. I have paid the whole amount to the supplier, and supplier is respondent number 4, Your Lordship. He has collected the amount as a part of index, Your Lordship.
What?
Respondent number 4 is the supplier, Your Lordship.
Who has filed this affidavit?
Filed by the magistrate.
What is your affidavit stand?
Upon cross-examination of the, my lord, GSTR 2A and my lord, 3B, founded, my lord, that amount has not been deposited. So my lord, the petitioner is not entitled for the benefit of the ITC.
ESTR 3B is the final return.
Well,
Subsequently, demand in DRC 07 was issued as reply submitted by the petitioner was not tenable, levying tax amount of rupees 2 lakh is of demand and penalty. Himself stated for liability of rupees so and so of GST amount and rupees when he had furnished certificates and payment in DR. Thereafter, balance amount of rupees to so and so levy tax and interest. The provisions of eligibility and conditions for taking input credit under the what? The affidavit comes and finishes.
Hello?
The affidavit doesn't, he quoted a provision.
That part, but my lord, so far as my lord, this amount of rupees 9,44,000 is concerned, that is the admitted amount, my lord, from the petitioner, because he has sought for rectification of a certain amount. We have rectified it. But this amount admittedly has not been deposited.
No, my lord. I have
Let's see your rectification.
My- the reply, your lordship.
No, rectification application.
Page 60.
Page 60, my lord.
It's
60, it starts from page 16, my lord.
no, madam. I'm not saying about the
Reply, my-
rectification order. I'm saying about the rectification application.
That order.
My lord, my lord, may kindly see page, page number 39, your lordship.
Oh, yeah, page
Page number-
58, page 50. With reference to that, I would like to state and submit before you that notice in ERC for the year demand where you have raised the demand of rupees 4 lakh. Amount of Now here, as regards 72,000, the petitioner definitely mentions this aspect in that page 59.
Yes, sir. In the slide.
So they categorically mention that this is to be paid by the other person.
My lord. I have availed the ITC based on the valid tax invoice received from the supplier, my lord.
Where's your reply?
It starts from page 36.
What?
Page 36. It starts from page 36, your lordship. Annexure 3.
Page
36, your lordship.
so called. Where's your reply?
reply of the show cause notice, page 36, Annexure 3, my lord.
It starts from 37, my lord, the main reply.
Main reply, yes, my lord.
And
The
the relevant will be
page 39,
2.7, 2.6,
6 to 2.7,
72,000.
my lord.
That we have purchased goods under invoice from CR Group having GST number so and so, the details of which are. You are CR Group.
No, respondent number
It is appearing.
4 is CR group. I have
Why?
purchased.
Have you deposited the amount? What? Take the mic and don't make this type of submissions unnecessary. The simple question is, you have not paid. And because of that, the petitioner is suffering. Then, have you paid or not?
Well, yesterday evening, I just received the instruction, my lord.
What is the instruction?
The client has not filed lordship return. Not
Client
submitted
has not filed return.
lordship. And after filing Kukalanama lordship, we are unable to contact with the client because he is.
He ran away.
No, my lord, he is under medical emergency lordship.
Emergency.
Therefore, lordship, we are not able to file affidavit also. Yesterday, somehow we contact with the client and then see.
Then I think, Mr.
National-
Kumar, this will be covered by the judgment. Huh?
Judgment is recorded in that case, my lord, he will be also liable. That may be recorded.
National plus 2, your
And
lord.
we will take my lord recourse, my lord, as part of.
We have to take recourse
He has
against them.
admitted already. I have annexed the WhatsApp chat also, your lord.
What is that? I have how many copies of this judgment you are going to give? Yes, what happened to your car? That one, customs.
I have received.
Got it?
I'm obliged, your lordship.
Yes. Madam Jia does a lot of customs, central excise, all these matters, huh?
It was listed in another court, your lordship. Thereafter,
Huh?
after my lord's order, your lordship, it was listed in another court.
Okay.
And then I've submitted that as per your lordship's order. I have already received that.
You
The
got the
matter
card.
was closed, your lordship. I'm obliged, your lordship.
So we therefore have to set aside the order, the rectification order. The not only the rectification order, the we need to set aside what? The demand made in the rectification order.
Yes, demand as well as.
Huh?
Yes.
Remaining is okay.
Remaining is okay.
So only the demand made on the ITC.
ITC.
So then nothing will remain, isn't it?
Yes.
Page 61,
My lord.
the rectification of order, the demand which have been made of 3,20,000. 3,20,000,
21,000.
21,012.
12.
We have to interfere with this. Okay. Heard Miss SSG, the learned counsel appearing on behalf of the petitioner. B. Gugoi, the learned standing counsel of the Finance and Taxation Department, and Mr. So-and-so who appears for the respondent number 4. The issue involved in the instant proceeding appears to be squarely covered by the judgment of the learned division bench of this court in the case of National Plasto Molding versus the state of Assam and 3 others, reported in 2024 $AS:7506-DB, wherein it was categorically held wherein the learned division bench of this court accepted the proposition of law laid down by the Delhi High Court, in the case of Conquest Merchandising India Private Limited versus Government of NCT of Delhi and others, reported in 2017 SCC Online, Del 11286. It is pertinent to take note of that the Delhi High Court, in the said case of Conquest Merchandising India Private Limited Supra, categorically held that the expression inverted comma dealer or class of dealers occurring in section 292G of the Delhi VAT Act should be interpreted as not including a purchasing dealer who has bona fide entered into purchase transactions with validly registered selling dealer who had issued tax invoices in accordance with section 50 of the said act, whereas where there is no mismatch of the transactions in Annexure 2A and 2B. It is also seen that the Delhi High Court had read down the expression dealer or class of dealers appearing in section 92G in the said manner. At paragraph number 54 of the said judgment, the Delhi High Court observed as hereinunder. Ekhonতে পাবো, huh? From the above quoted portion of the order, above quoted paragraph, it is apparently clear that the Delhi High Court, while reading down the said provision of section, the expression dealer or class of dealers, opined that the department is precluded for invoking section 92G of the DVAT to deny ITC to a purchasing dealer who has bona fidely entered into a purchase transaction with a registered selling dealer who had issued a tax invoice reflecting the TIN number. It was also mentioned that in the event the selling dealer had failed to deposit the tax collected by him from the purchasing dealer, the remedy for the department would be to proceed against the defaulting selling dealer to recover such tax and not deny the purchasing dealer the ITC. It is also seen that the learned division bench of this court, in the case of National Plasto Molding Supra, categorically held that the issue pertaining to section 16.2C and 16.2D of the Assam Goods and Service Tax Act 2017 squarely applies to the proposition so laid down by the Delhi High Court in the case of inquest. Inquest Merchandising India Private Limited, Supra. In the backdrop of the above, let this court take note of the facts which are involved in the instant proceedings. The petitioner herein is a registered dealer, is a registered business entity you are a proprietorship firm?
My lord.
What is that? It's a proprietorship firm. The petitioner herein is a proprietorship firm. registered under the provisions of the Central Goods and Service Tax Act. What is your registration number?
My lord. GST 18 AC
Bearing registration number
18 AC
18ACJ PH5004J1ZP/18. Isn't it?
Yes, madam.
I don't think /18 will come. It will finish with P.
P, madam.
ZP. Huh? /18 na lage. During the financial year which year? 17/8, 2017 and 18. The petitioner purchased from the respondent number 4 generators of a total value of rupees 9,44,000, out of which the Central Goods and Service Tax and State Goods and Service Tax was rupees 72,000 each. The said payment was duly made Be that as it may, the petitioner was issued a show cause notice on 13/9/2023. Wherein it was intimated to the petitioner that the petitioner was liable to make payment of tax and interest along with penalty on the question of excess ITC claimed. The petitioner submitted a reply explaining the ITC claimed insofar as the payment of GST on the purchase so made from the respondent number 4 Few details were provided at serial number at paragraphs 2.6 and 2.7 of the said reply. Be it as it may, the order was passed on 30/9/2023. That the petitioner was liable to pay tax to the amount of rupees 2,08,802, interest of rupees 2,16,632, and penalty of rupees 20,880. Pursuant thereto, the petitioner filed an application for rectification on 29/1/2024, thereby again explaining that there was no dues to be paid by the petitioner, inasmuch as the ITC credits were duly, inasmuch as there was no claim of excess ITC claim. The respondent authorities thereupon rectified the order dated 31/12/2023 by an order dated 10/4/2024, whereby the petitioner was directed to make payment, whereby it was observed, whereby all other contentions of the petitioner were accepted except the claim of the ITC, except the claim of the input tax credit by the petitioner on the goods purchased from the respondent number 4 was rejected. It is under such circumstances the present writ petition has been filed. The record reveals that after issuance of notice, the respondent number 4 duly appeared and submitted that though the the record reveals that after issuance of notice, the state respondents filed their affidavit in opposition. A perusal of the said affidavit in opposition shows that on account of the respondent number 4 not filing the returns, the ITC amount has been claimed from the petitioner, who is the purchasing dealer. It is therefore apparent that the said affidavit in opposition has been filed without taking into consideration the judgment of the learned division bench in the case of National Plasto Molding Supra. Mr. So-and-so, who also appeared on behalf of the respondent number 4, who though admitted that the respondent number 4 duly received the GST amount, but the respondent number 4 paid GST amount which had been paid by the petitioner at the time of purchase of the generators. But the respondent number 4 had not filed the returns. Isn't that your instruction? That the respondent number 4 has not filed the returns. Taking into account the above, it is the opinion of this court that as the petitioner had duly made payment to the petition respondent number 4 at the time of purchasing the generators, the GST of rupees 72,000 each on account of central goods and service tax as well as state goods and service tax, as would be apparent from the tax invoice cum delivery challan dated 14/2/2018, which is enclosed as Annexure 6 to the writ petition. The imposition of the ITC or holding the petitioner have made excess claim of ITC is contrary to the law laid down by the learned division bench of this court in National Plasto Molding Supra. Accordingly, this court therefore disposes of the instant writ petition, thereby interfering with the demands so made upon the petitioner on the basis of the ordered rectification order dated 10/4/2024 for the financial year 2017 and 18. Accordingly, the writ petition stands disposed of with the following observations and directions. The impugned order dated 10/4/2024 in reference number number 2 issued by the respondent authorities, thereby demanding an amount of rupees
1 lakh, page 61, your lordship.
What?
Page 61, your lordship. 1,60,506 rupees.
An amount of rupees. What 1 lakh? 3 lakh, 1,60,506. On account of CGST and rupees 1,60,506 on account of SGST is set aside and quashed. Number 2, the setting aside and quashing of the order dated 10/4/2024 shall not preclude the respondent authorities to initiate steps for recovery against the respondent number 4 in terms with the provisions of the Assam State or Assam?
State GST.
Huh?
State GST.
No, what is the full name?
Assam State.
Assam State or Assam Goods and Service Tax Act?
Assam.
This is
Assam
Tax
Goods and
Act
Service Tax.
2017.
SGST.
Assam Goods and Service Tax Act 2017. The petition stands disposed.
For hearing item 21.
Yes.
May I please, your lordship? My lordship, the petitioner hearing is challenging with regard to the penalty imposed upon the petitioner, where my lordship, one major penalty and one minor penalty is imposed upon the petitioner under one heading, under one punishment. My lordship, here the petitioner has prayed also for setting aside and quashing of the impugned order by which the penalty is imposed. And the case of the petitioner herein was that, my lordship, petitioner has joined as LD assistant in the year 11/1/1995, my lordship. And while he was lastly working as miscase assistant and execution assistant at the court of Munsif number 1 Kasar at Silchar.
What were the two penalties imposed?
My lordship, One penalty, the two penalty, one was reduction to lower time scale of pay from basic pay of rupees 10,570 to basic pay of rupees 7,930 for a period of 3 years with effect from 21/11/2011. And the petitioner would not earn increment of pay during these 3 years, my lordship. And
Is the major?
Yes, my lordship, the first
Minor?
the first part was major and the other second part was minor, my
What is
lordship.
the minor?
Minor, this was with regard to that the petitioner would not earn any increment of pay during his 3 years. This falls under 7(2) of minor penalty, my lordship. And the first part, it falls under 7(4) of the major penalty. And moreover, my lordship, if we go by the penalty also,
Yes.
yes, by the penalty, because two punishments are blended in a compound and simultaneously imposed upon the petitioner, my lordship. Because if my lordship will be
So your first one of your contentions is
my lordship.
that look here, you cannot impose two penalties, a minor and a major.
Yes, my lordship, it can be imposed if the punishment is if it is under two charges, it is stated that this for this penalty and for this too. Here in the case of the petitioner, it was simultaneously blended two in the impugned punishment. One punishment, it was under one charge, the punishments were blended, which cannot be done according to me, my lordship. Moreover, my lordship, this is the case. And secondly, my lordship, by the facts of the case itself, if my lordship, I am praying for the setting aside of the bill because by the facts of the case, the petitioner herein is innocent with regard to his findings, as according he has submitted his reply on occasions in which he has not committed any error. Though there was no lapse on his part, because what happened in this case was that a title suit was it was proceeded. And then, my lordship, after the title suit was decreed with cause, title execution was there. During the pendency of the title execution, one of the defendant, they have approached the High Court by filing one civil revision petition. As the civil revisions petition got stay, the writ was not executed, and there was in the title execution was also stayed, my lordship. During the pendency of the proceeding of civil revision petition, as it was dismissed, the same has been submitted to the executing court that since it was dismissed, it may proceed. And so the Honorable Court proceeded with the execution decree. The part here for challenge was that the executing court, in which the title execution was pending, in the same court, another defendant who has not approached the High Court has filed a petition under Order 9, Rule 13 to set aside the ex parte decree. And in that petition, in the heading of the petition,
where did they file the Order 9 Rule 13 is in the suit?
Yes.
Order 9 Rule 13 has
for
to be
the
in
suit,
the suit,
for the
not
suit.
in the execution.
Not in the execution, for the suit. But what they did was that in the cause title of the plaint, they have stated with regard to the setting aside of the ex parte of the suit. But in the prayer portion, which I have observed, in the prayer portion, they have made a prayer to stay the execution process.
Obviously.
Yes, they have. Yes, they have. But in the suit, they does not. So what happened was that the Honorable Court, since both the courts were same, the court has passed an order in which the court has stayed the ex parte decree, not this execution, ex parte decree, my lordship. Yes. So what happened was that the council did not obtain the certified copy, and he has not submitted before in the execution case, my lordship. Secondly, he has not even prayed before the Honorable Court to call for the record of the execution. And as such, the Honorable Court, also staying the decree, has not called for the record of the execution. So in the meantime, the writ executed, my lordship. So after the writ was
executed,
writ executed, my lordship.
How?
How? Because
How
writ was executed by my lordship. Because it was a shop, sweet shop, So, my lordship, a report was submitted by the Nazir, civil Nazir, that with reference to your honor's order dated, I have the report that a writ in title execution case number dash has already been executed on 10/8/11, and the report along with writ has already been submitted. He has been vacated, my lordship, in the meantime, because it was a sweet shop. It was a sweet shop. Sweet shop.
Decree was for what?
Decree was for decree for seeking a decree for ejectment, my lordship.
Ejectment carried out.
Yes, my lordship. And so this phase of the petitioner started as one of the defendants thereafter wrote a complaint that though there was a stay of the proceeding, but still the writ was executed.
Which shop was
The defendants.
Was he one of the defendant which shop was?
Yes, my lordship. Yes, my lordship.
To obtain that stay in an order 9 rule 13.
Yes, my lordship. Yes.
Because getting the stay, then also they carried out.
Yes, my lordship.
What happened?
Here, my lordship, there were
What did the court do?
the court thereafter has then as the complaint was lodged that an irregularity was committed, the court of the Honorable Court of Honorable Court of Munsif number 1 has forwarded the complaint to the session judge, and thereafter on the basis of which the departmental proceedings started, my lordship.
Okay, now what did the court do?
The court with regard to execution thereafter, since execution was done, my lordship, that part already execution was done.
That's good. So the 9 rule 13.
It was pending. It was pending.
When it was filed, that application, when it was filed by one of the defendants.
Lordship.
That defendant was
my lordship.
Didn't it? From the same court. This aspect of stay was not brought to the attention of the.
Yes, not their contention is, my lordship. Their contention was that since the Order 9 Rule 13 petition filed before the court, and since the title execution pending court was same, so it should have been the petitioner who was at that point miscase assistant, execution assistance, to have brought to the notice of the Honorable Court. Whereas,
when the order is passed,
yes, my lordship.
and that court is executing,
yes, my lordship.
what is the impact? The order immediately goes to that branch, the executing branch.
My lordship.
Now, executing branch is whom? That person concerned, the
my
petitioner
lordship.
concerned.
My lordship. My
so
lordship.
that he has been duly informed.
My lordship.
Because the court had passed that order.
Yes, my lordship.
Then why did he not inform at the time of issuance of the writ? Was the writ issued earlier or before?
Writ after, thereafter.
So therefore, the writ when it was issued, why didn't he inform that there is an order?
My lordship, with regard to with due respect, with regard to the order, what happened was that the execution of the ex parte decree in title suit number dash shall remain state. The order passed by the court, page 78. It was the case number of the execution case was not referred. Neither the records were called for. Yes, I understand, my lordship. I'm understanding, my lordship.
So the thing is like this. You practice in the trial courts?
My lordship. Sometimes. It's not so, my lordship.
When an execution happens, when a same court is executing.
My lordship.
And more particularly when it is the Munsif one. It must be Munsif one?
Yes, my lordship, Munsif one.
Normally what happens, the Sahistadar of the Munsif number 1 is the main person.
My
He
lordship.
must be the Sahistadar.
My lordship.
He's the main person out there. Now what happens when an order is being passed, stay of an execution? You don't need a certified copy. Because that order is given to your Sahistadar. Now that particular Sahistadar has to therefore note it and bring it to the attention of the executing court. That look here, this is what has happened. We have granted a stay. Yes, there is obviously a mistake of that judge also. There's no quarrel that the judge is also responsible for that. He should have been more knowing it. And within what time did it happen? When was the writ issued?
My lordship, the writ writ was issued on 26, my lordship, on 3/8/2011.
So on 21/7, the order was passed.
Yes, my lordship.
On 3/8, he should have remembered it about the property. Maybe there might be so many.
Yeah.
He may not have remembered. So that very court passed that order.
My lordship.
And then when it was for report,
Yes,
the writ is issued, it will be given for report.
my lordship.
Now 3/8 was the Iman and the petition was filed by the debtor for recalling of the writ.
My lordship.
Fixed for so and so for report of the Nazir.
My lordship.
Now on 10/8 the petition was filed.
My
The
lordship.
report of the Saristadar and Nazir was seen on 12/8.
My lordship.
So when was the execution carried out?
Execution was carried out on 10/8 to my lordship, on 10/8/2011.
And on that very date, an application was filed for
Yes.
recalling of the writ.
Yes, already by that time the execution took place too.
Now the question is during this period,
Yes, my lordship.
where after 21/7/2011 to 3/8/2011,
Yes.
it was his duty not to place it, and that is the result.
Yes, yes.
Now, what was the petitioner working as?
Petitioner was working at that point of time as Miss Case Assistant and Execution Assistant.
Huh?
Miss Case Assistant and Execution Assistant.
Miss case assistant
Assistant and Execution Assistant.
Now, what is
and-
the duty of the miss case assistant and execution assistant?
Lordship, the Miss Case Assistant, generally when a petition is filed of.
It will be, madam,
But-
don't come up with general.
Sir,
Go as per the civil rules and order.
Yes,
You have it.
yes.
You have it.
Also, no, there's no, my lordship.
Huh?
Not, no, my lordship.
You have to go by that.
Yes.
Is there a post of miss case assistant?
Yes, my lordship, they are, because since
You will find out the duty of the miss case assistant.
lordship.
I'm trying to help you
Yes,
out.
my lordship, I understand.
You help you yourself.
My lordship.
I'm explaining it. Bifurcating, delineating. Let us see whether there is the post of miss case assistant. Listen. Judgment and decree. Now, is the miss case assistant?
My lordship.
Where is the post of miss case assistant? Yes, Mr. Das, where is the post of miss case assistant?
He was entrusted with the work of Miss Case Assistant and Executing Assistant. my lord.
Miss case assistant is different. Where is the concept of a miss case assistant?
My lord,
If he must be doing what? What was his job, nature of the job?
lordship,
Because
My
you see,
lordship,
you have to understand, Mr. Das,
yes,
one is a suit proceeding, one is an execution proceeding.
My
Suit
lordship.
proceedings is in the suit, execution proceedings is in the execution.
so,
If it was a different court, it would have been the person is completely different.
so far as this, my learned sister is, my lord, referring to regarding that some other proceeding, or basically the petitioner is trying to, basically.
For her to refer
No.
is not necessary,
No, no.
I know that.
No, but
My question is only,
the petitioner is basically trying to say that he was
Did
not
you-
aware.
no, I'm not on that. The petitioner may not be aware is another thing. But
Yes.
one is whether he was entrusted with the work.
He admitted that, my lord. He was aware of the execution, page 112, during inquiry.
Uh,
That's why.
My lordship, before proceeding, I have one thing to say. In page number 104, one of the PW2 has stated that,
112. Let us wait.
112, third paragraph, my lord. This is the finding of the inquiry officer.
No, finding of an inquiry is they may find many things. I'm not on finding of it.
No, finding was
I'm
based
on
on
so where is the admission on writing or evidence?
Lordship will
No,
kindly.
no. On evidence.
Um,
No. Has he submitted any defense thereby admitting? No. Mr. Das,
I'm
kindly
sorry.
appreciate. Had he admitted in his statement of defense? We are on the finding of fact. Has he submitted on the statement of defense or during the cross-examination or during the evidence? It has been categorically pointed out or evidence have been led to the effect that he had that duty and in pursuance to the duty he has failed to do that. My question is that.
3 lines, my lord. 3 lines.
Yes.
After going through the stay order passed in Miss Case number 36 of 2011,
Para?
my lord, 112.
Got it.
third
After going
paragraph.
through the stay order.
Yes, passed in Miss Case number so and so, he did not approach the learned Munshi for clarification as to which title execution case has been stayed, while the said order passed in Miss Case number so and so. As such, it is abundantly clear that Sanamia Chaudhary, although prior to the date of execution of decree in so and so, had the knowledge that there was a stay order passed in so and so, but he being the concerned dealing assistant, although has the lawful duty to apprise the matter to the learned Munship number 1, but he did nothing rather to remain mum and thereby facilitating the execution of the decree title execution 6 oblique 2010 suppressing the fact of existence of the stay order.
Okay. Now,
This was the fine.
now show me that it was his duty. Where is his duty? That he was conferred with the duty. Where is the proof? That is the basic fundamental proof. Where is it? From your records? Where is the records?
Records I have.
Where is the proof that he was entrusted with the execution? Have you given that proof?
No, I can from inquiry.
No, not from the
to
inquiry.
see the record.
Yes.
Lordship, may I assist in it? It's 104, my lordship, page number 104. Yes, the last paragraph, one of the PW2, last paragraph, my lordship. On the other hand, Srimati Swapna Chakraborty, who is
Where?
104, my lordship, the last paragraph. On the other hand,
Is Swapna Chakraborty, who is examined by the presenting side, as PW stated that since so and so she has been working as the solicitor of the municipal courts, and she had to supervise works of all dealing assistants of the solicitor. She found so and so as the money suit assistant, Miss Case assistant, bill assistant, and also assigned with the works of preparing statement of her office since her joining. Although she
My
was
lordship.
transferred of the solicitor of the month of July, but she told hold the post of solicitor of Munshi till so and so. In so and so, there was an order of dated so and so for issuance of a writ. Case record shows that the said writ was reissued on 5/8. The said writ was checked and verified by then. Execution dealing assistant so and so. Execution exhibit 2 is the said writ wherein by so and so. 2.5 is the signature of Sonia Chaudhary, which she knows from official correspondence.
That's my lordship. So what I'm trying to project is my lordship was asking whether he was, so it is admitted to be, means he was working as Miss Case assistant and executed by the her evidence. In her evidence, my lordship.
Right,
But,
right.
to be
Let us see
making
the
a fair,
cross-
yes.
the cross it.
Yeah. Was the present solution.
You. Position 4. Well, PW2, na?
My lordship.
Was overburdened with official works. He was also mentally disturbed due to his family affairs. Whenever an official is overburdened with works, there is possibility of omitting it. As per records in so and so, no notice have been issued to the parties of the execution case, but it is not the duty of the execution dealing assistant, but it is the duty of them to give notice to the parties before proceeding. Then, also, of Sanya. Execution was issued. Who is N.K. Taran?
My lordship, he was the civil, my lordship, civil Nazir, I guess. Yes, my lordship, he was civil Nazir.
Taking my signature and the return by Mr. Triya for me was beyond his. I was one of the members of the. They're not supposed to act by the dealing assistant on last order alone by the court. On so and so was fixed for hearing both sides as per the order dated so and so. Accordingly, on so and so decree holder appeared, but in the said order it does not reveal the judgment debtor appeared. In the order dated so and so, it is mentioned that CRP so and so has been dismissed and the earlier interim order was vacated by the Honorable High Court. And on being satisfied on the basis of the order of the year, I reissued the writ of possession without having the knowledge that at that time that there was another stay order passed by me in this case. The judge said so. Subroto Iman. He's who? Munsif one. He's the person who. See his cross. That Munsif who did it. On 3/8/11, no, it is not supposed to act by the dealing assistant on the basis of the last order alone by the court. On so and so, 3/8/2011, the title execution case number was fixed for hearing of both sides as per the order dated 23/8/2006/2011. Accordingly, on so and so, the decree holder appeared, but in the said order, it does not reveal that the JD appeared. In the order dated so and so, it is mentioned that CRP has been dismissed and the earlier interim stay order was vacated by the Honorable High Court. And on being satisfied on the basis of the order of the Honorable High Court, I reissued the writ of possession without having knowledge at that time that there was another stay order passed by me in miss case number so and so. I found Sanya works as so and so, miss case so and also assigned with works preparing statements. Although in the Iman I was transferred Iman person against so and so, written execution cases are submitted by parties concerned in the concern and therefore it has to be checked and verified by the concerned dealing assistant. The writ was checked and verified by the then execution dealing assistant Sania Mia Chaudhary. Okay. Now tell me one thing. The writ was issued by the petitioner. There is no quarrel. And under the writ was issued by the court under the ear of the petitioner. The petitioner checked it. That miscase order, which was passed in order 9 rule 13, also came to the notice of the petitioner. How is it possible? Where is the link?
Because in the findings of the inquiry officer, page 109, if your lordships just go through these findings of the inquiry officer, it discuss all the evidence. My lord. It will clarify the entire issue, my lord. He was the miscase and he was the executing assistant. He never said that the file did not come to me, my lord.
Passed an order. What steps were taken? Any disciplinary proceedings taken against the judge?
That I'll have to.
Nothing. He's also equally responsible.
I don't even know. Lordship will kindly see the evidence of PW2 discussed in the page 110, my lord. While she inquired Sanamia Chaudhary as to why she did not show her the writ so-and-so, stay order passed in Miss so-and-so, Sanamia Chaudhary told her that due to pressure workload, Mr. Chaudhary forgot to show her the same. That means you are aware.
No, in the cross of so-and-so, cross of that particular person, the PW2, what she says is this. You listen. Sanayana Mia Chaudhary was overburdened with official works. He was also mentally disturbed due to his family affairs. Whenever any official is overburdened with works, there is a possibility of committing error. As per case record in title execution, no notice has been issued to the parties of the execution case. But it is not the duty of the execution dealing assistant, but it is the duty of Nazir to give notice to the parties before proceeding to the decretal property subject for execution. This is her cross. And this aspect is not there in the inquiry.
This may be her chief.
No, cross.
No. I'm not saying that
So
thing.
therefore, they have
Because
only
this finding
picked up
of
that.
this finding of the inquiry officer.
The finding of fact, you have only taken into account this aspect. You have not taken into account the other. You see, the chief, this particular person,
chief.
Swapna Chakraborty, what is saying that I've been working as Seristadar. In so-and-so, there was an order dated so-and-so for reissuing a case record. This area was verified and so-and-so, which I know. in the case record of when nothing is there to show that any notice about execution of the decree has been issued to the on the judgment date. Prior to 2009, I worked with so and so. In the said report, I have mentioned that the executing dealing issued the writ on so and so for different work of the court, different dealing assistants are assigned, and they used to discharge the respective assigned job, and whenever necessary, the concerned dealing assistant obtains signature of the presiding officer. Any other official dealing assistant of other bench has no authority to deal with the matter of job or other so and so. Nazrat branch is a separate branch which is also involved with the works of the Munsif. In the contiguous left of my table of my office, Sania used to sit. While I inquired with so and so as to why he did not show me the writ of title execution and the stay order dated so and so, told me that due to pressure, workload, he forgot to show me the same. In my report, I have mentioned that the learned lawyer for the parties did not take steps in the execution proceedings. On so and so, I put my endorsement in the letter dated so and so addressing to the reserve officer by the SP for detailment of the armed forces for execution of the decree in so and so, wherein the learned Munsif vide his endorsement assigned to me to remain in charge of the office of Nazrat till the return of the Nazir for execution of the decree entitled in my signature. Sanai Mia Chaudhary was overburdened with official work. He was also mentally disturbed due to his family affairs. Whenever any official is overburdened with work, there is a possibility of committing error. As per case record in so and so, no notice have been issued to the parties of the execution case, but it is not the duty of the execution dealing assistant, but it is the duty of the Nazir to give notice to the parties before proceeding to the decretal property subject for execution. And
So
when
for-
does the police help come in? Tell me.
Yeah. No,
No,
so far
no,
as this,
no.
this,
Council, wait.
yes.
Order 21, Rule 35 comes into picture when there is a report being given that the decree holder who is there is objecting to it. And who gives the report? The report is given by the Nazir. This is how an execution goes. So when he gives the report, the Nazir looks into the court, then thereupon issues the police help. Now, if you see the report of this particular, the evidence of this particular person concerned, she categorically says that till 9/8 they did not take any steps. The writ was issued on 3/8.
Yes.
9/8 no steps were taken. On 9/8
The advocate or the parties,
by
decree holder.
the party.
Yes.
On 9/8 they moved the police reserve. And then on that day, this particular person who was the solicitor, she puts the signature out there. And then it goes for the thing.
So far as Milord, reissuance of writ is concerned is fine. But this evidence of the PW2 that Sanaimia Chaudhary told her that due to pressure and workload, Mr. Chaudhary forgot to show her the same. That means Mr. Chaudhary was aware of the order passed by.
Isn't that a hearsay evidence?
I'm just coming, my lord.
No,
I'm
no,
just
no.
coming. My lord, this was.
I would have understood, Mr. Counsel, if it was done by any other official or any inquiry officer, it's okay. But this is a pure hearsay evidence.
No, I'll just explain, my lord.
Explain.
I'm not explaining.
Why these aspects have not been taken? You see,
I'll just explain.
Position
My lord,
of here.
This is the examination in chief, which I am reading, my lord. And in
No,
cross,
that's not examination in chief. You're wrong.
Her statement.
No, this was said at the time when the Nazir, you see, T.K. Taran was the Nazir.
Yes.
He cross-examined. Sanya, this PW2 said that at the time when for the delinquent Nazir, the report was given. Kindly see this. This is how the evidence is.
She told that he forgot to show the same.
No. Kindly see this.
Yes. And my lord will also kindly.
My only another fact, you find out whether the Nazir has been taken into action.
Yes.
Yes.
Yes, yes, my lordship. By the
Has
impure.
it been
Yes.
dismissed?
No, my lordship. In the conclusion was, in view of the above, it is found the source of negligence on duty on the part of the NK Taran Nazir is proved, and raised allegations are not proved against Mr. Taran, whereas charge of impropriety, misconduct, and gross negligence in duty against the delinquent employee Sanaimia Soduri being government servant is proved.
What happened to that Nazir? Has he been thrown out from the job or not?
No, my lordship, only because it is found charge of negligence on duty was only proved against him and not the other.
He's the main person responsible. The
100
Munsif, the Seristadar was responsible, and that Seristadar should also be one of the charge sheeted employees. He was under his signature, it has gone. She doesn't say much in the cross, chief. It is only in that cross that has come out, what you are saying. You see that?
NK Taran,
Ah.
cross for delinquent, that is the charge officer.
No, that is for that particular one, the Nazir. The Nazir is the NK Taran. And then you see the next one. The
This
next
is
one.
a DP of
Of both together. Now you see the
Janu,
next
Janu,
page.
Janu.
And what was the punishment imposed upon the Nazir?
That, my lordship, my documents are not clear. Might be in record.
I think the records will be there.
Record is there.
Because Mr.
Yes.
Das, what I'm looking
During cross of the delinquent, that is in the case of N Taran, this fact came out.
This fact came out. Then you see the next page.
It's a part of the evidence.
Understood. See the next page.
Yes. Sanamia Chaudhary was overburdened with official work fine. He was also mentally disturbed due to his family affairs fine. Whenever any official is overburdened with work, there is possibility of committing error. As per case record in so-and-so, no notice has been issued to the parties of the execution case, but it is not the duty of the executing dealing assistant, but it is duty of the Nazir to give notice to the parties before proceeding to the decretal property subject for execution. Absolutely fine.
So here the Nazir did not issue the notice. The notice, if it see
the allegation is in the departmental proceeding is that, my lord, despite having knowledge of passing of the order, why you did not take it to its logical conclusion? It was not that why notice was not issued in the execution case number so and so. That was not the allegation.
No. The allegation against him is this.
Exactly.
See, the thing is not that. The question is, first of all, you have to see that aspect that clause has a vital bearing on the question of proportionality of the punishment.
No, if his finding is
on the question of proportionality of the punishment, that clause has its own relevance. If you are overburdening an officer, you will expect that you pass an order on 20, you may have passed an order on 27. Now let me tell you how it is. On 27, 2011, an order is being passed to the effect that stay this execution. Okay. On 3/8/2025, 11, the High Court's matter has been taken, order has been placed before the Munsif, saying that we vacate this, go ahead with the execution. Okay. So the Munsif thereupon issues the writ.
Yes.
Now, once the writ is being issued, then you see on 5/8 the matter is being taken up. Then most probably an application must have been filed by somebody to the effect that police help is required. Because the police help automatically is not issued. The police help is required. The moment the police help is required, so 5/8/2011, the police help is being given by the magistrate. Okay. Now, if this magistrate can forget Because you don't, at the time of execution, you don't see the main file. The suit file is out. The suit file is out. You don't look into the suit file. You go into the execution court, and this is how the execution is. And if you see the execution proceedings at that point of time, after I joined out here, I made it a point and I passed an order that execution proceedings should be taken up at every day at 10:30. And nowadays, in view of various judgments, execution proceedings are given more importance. At that point of time, the execution matter never used to come to the court. At 4:30, the execution file comes to the court and the court just puts a signature. This is how execution was treated. We are concerned with 2011. Now, this matter goes out there, and then an application is now being filed out there, most probably on 5/8, which is apparent from there, that we need the police help. Police help direction is being given. After the police help direction is given, 4 days thereafter, no steps is being taken. Means what is that? The court, the moment the court grants it, then that means the Nazir has visited after third. But what in fact happens is the Nazir never visits. He directly goes and files an application, we need the police help. This is how things happen. Now, thereupon, when he files the application, the court grants it, see about the amount. Now, in those orders which are given, normally what happens? You ask the police, how much is the amount? But here, it is acting very fast. This person concerned, I'm telling you, this person who, number 2, PW2. No, PW2.
Yes.
He is the most important person who has done this mischief. Yes. Without his assistance, this amount of what will be the amount to be deposited for the police help could not have been done. It is not done by the dealing assistant. This could not have been done without the help of that person. And when he fixes this amount, then the amount is deposited, the challan is taken, challan is deposited before him, and then the police comes. This is the procedure.
Correct.
Now, these are things, what has happened, here the officers have just took him into consideration out here, imposed this penalty, finding him to be the weakest of the fry amongst the monks.
The officer, if I have understood correctly, this Chapna Chakraborty, she was also unaware that there was an order.
No.
She was also unaware.
In fact, she has to be aware because of the fact that it is through her minsif. She is the Saristadar of the court. She has to be aware of that. It is under her. You see, what happens in the civil court? You have a Saristadar of this court who sits out there in the office. And this particular person concerned looks into everything, goes through him. The records, the files are inserted not by the dealing assistant. It is all done through him. This is how it works.
But the evidence say in the writ of
Evidence has been all lopsided out here. This is how
title execute case number, there is no signature of her.
And look at her cross, which has been done by N.K. Taran, the last portion of her cross of that PW2.
While I inquired Sanamia Chaudhary as to why.
No, thereafter, you are hitting on. No.
Asked.
Last portion of that page.
Okay, fine.
You are only insisting on that paragraph.
I put my endorsement in the letter dated so-and-so addressing to the reserve officer by the SP Asar for
No,
detailment of-
one line before, 2 lines. No steps were taken.
While I inquired Sanamia Chaudhary as to why he did not show me the writ of so-and-so, stay order passed in so-and-so, Sanamia Chaudhary told me that due to pressure workload, he forgot to show me the same. This was
after that.
After that.
You want
in
to
my
read that
report,
line.
in my report, I have mentioned that the learned lawyer for the parties did not take steps in execution proceeding. On so and so, I put my endorsement in the letter dated so and so. Lord, this
is very-
while I inquired,
read that.
yes.
Yeah.
In my report, I have mentioned that learned lawyers for the parties did not take steps in execution proceeding. On 9/8/2011, I put my endorsement in the letter dated 9/8/2011 addressing to the reserve officer by the SP Kachar for detailment of armed forces for execution of
So
the
this
decree in
happens, this,
9/8.
you see, the solicitor doesn't do it on his own or her own. It has to be done it has to be again preceded by an order passed by the Munsif. So this Munsif must have passed an order around 5/8 or something. Now therefore in 9/8 he does it. And on 10th, the execution happens.
Yes.
See this. It is his duty also, that particular petitioner.
No, that's fine, my lord. But it is the duty of the petitioner also. It is the duty of the petitioner.
No, it is not a duty of such magnitude, which is absolutely, it is the responsibility of the Munsif first.
No,
he says that I forgot. Petition. The Munsif says I can forget. If he can forget and that person cannot forget. My question is this.
No, he has seen it. Oh, my lord, that analogy I can appreciate.
No. My question is, you see, you are imposing a major punishment. Yes, minor punishment, increment or something, small thing is okay. But major punishment, this is a question of proportionality. I'm not under the facts and all, but it is a question of proportionality. The thing is that how many works were being endorsed to her? You see, if it was a case of a munsif, of a dealing assistant out there in any other courts, in outside Kamrup Metro, it's a different thing. The munsif number one court, is not only the court for these, deals with all these things pertaining to execution, dealing and all these things. Every NJ case is being submitted there.
There was never any application by the petitioner saying that, look, I am overburdened. I have been.
It is not required. It is admitted by the PW2.
No.
It is
After the
admitted.
incident, after the damage was done,
have duly admitted that.
page 110, the evidence of the petitioner lordship will kindly have a look. Third paragraph.
Of?
Page 110, the inquiry report. Third paragraph, DW7. DW7, Sanamia Chaudhary himself stated in his evidence that since last 2 years he was working in execution branch in the establishment of Munshif number 1 in addition to his assigned duty of miscase number so and so.
No, miscase and money assistant.
Money suit assistant, etc. Writ in title execution case number so and so has been prepared by him on submission of the same by the learned lawyer for the DH on 5/8/2011. He endorsed in the said writ for execution of the decree by deploying police force and to hand over the possession of the decretal shop house to by breaking the lock, etc. Following last order passed on 3/8/2011 in the title execute case number so and so. After 2-3 days from 5/8/2011, but before 10/8/2011, he has gone through the case record of miscase number so and so and found that there was a stay order, but there is no mention of any title execution case number in the said stay order. On 3/8/2011, neither of the party of miscase number so and so took any step in the said case. Later on the said date on so and so 3/8/2011, DH by filing a petition got an order in the said case, but judgment debtor did not take any steps. Thereafter, what happened with writ of title execution case number 6/2010, he cannot say, but on 12/8/2011, the writ of title execution case number 6/2010 returned to him after execution. So he himself stated after 2-3 days from 5/8.
He must have, but is there a mention? Where is the order past the stay in title of miscase number 36? I think that must be a part of the evidence.
Yes, has to be.
No me.
That's on.
See, 9/8 is this document where the superintendent of police writes to the please depute section of so and so. Cost, the cost of in this regard has already been deposited by TC dated 31/5/2010. Dark book Munsif, Civil Nazir, notice in miscase. Notice in miscase.
No, when he himself had admitted that he had seen the order, but he did not show it. That itself, in my humble submission, is sufficient proof.
No, it is not sufficient.
No, we, Lord, the there has to be some evidence to come to a conclusion. It's not that there has to be proof beyond reasonable doubt, but sufficiency of evidence, perhaps we will not be able to travel to that extent in the writ court.
Mr. Counsel, we know how much to exercise our jurisdiction. You need not
Lord, I'm
inform
extremely
us.
sorry. I'm extremely sorry, my lord. I'm just expressing my concern.
The writ
with-
court would exercise the jurisdiction where it is, but here is a case that whether it should be only
petition
here.
is-
Now,
petition-
show me that order of, why 3611, without that document of stay being there, can there be at all a stay? Where is the stay order?
Stay order was dated 27/2011. No.
27, and that,
27
in that
2011.
case, I pass an order on 21/7 to the, for issuance of a notice to appeal and directed stay of the execution of an ex parte decree till the disposal of that mispetition. The record was sent back to the execution branch on the same day, as usual, but the execution assistant so and so for reasons best known did not do the needful in pursuance to that order, so that this fact of stay could attract the notice of this court while so and so. This is what he has written. Now, where is that order?
21/7/11, my lordship.
Uh,
Page 78. 78, the original 79. Type copy 78, the original 71/9.
79. Where?
79, the original, 21/7/2011. Peru CR, hard learned advocate for the petitioner, issue notice to the OP. The execution of the ex parte decree in title suit, their sale remains state until disposal of this petition.
Lordship will kindly have page 48, order dated 3/8/2011 and 10/8/2011.
Wait, 48.
48 and 49.
Yes, what does it say?
Decree holder
Is represented.
is represented. Decree holder has submitted a copy of the
Order dated.
order dated so and so passed in the Honorable High Court so and so, by which the revision petition has been dismissed and the earlier interim order is vacated, seen the petition filed by the so and so.
For issuance of writ for delivery of possession of possession with the help of Nazir
Nazir.
and armed forces. See,
Forces.
see, this is
And-
if the see, this is the basic blunder he has done. Why armed forces required? Why armed forces required on the first date on 3/8? No. You see, no. This is a
may have
case.
committed
No, if he has committed a mistake on 3/8, first of all, it is. If you see the CPC, this is a blunder made by this officer. First day, on what basis can the district, the officer could send it and say that apply the armed forces? Kindly see, do you have a copy of the CPC? Show him. Order 21 will 35.
So 35.
You go Anyone exercise that on the armed forces on the first day? In petition filed by decree holder for issuance of a writ for delivery of the decree with the help of the Nazir and armed forces heard. Permit share.
No,
What is this?
perusal share
Peruse the share.
Involving the order dated dash dash and dash.
So and so.
Being satisfied, I allowed
Now the petition
reissue the writ.
for report. Now you see 10-8. Now tell me, if the police help is not being taken, either there should have been direction that the police help. There is no order even with the police help. See this order? There is no order of the police help. Then without the police help also this is being done. Who has done that? Tell me, how is it possible when that particular...
Charge herein is not who has done the
No, Mr. Counsel, you see, no, it is not a question of the charge. Who is actually responsible? We are concerned out here. After all, these we have to look into it as these are also official. These are also ministerial staff under us. True. We are not only exercising the jurisdiction out here under 226, we are also looking into as a supervisory jurisdiction out here to the effect that how it's being done. First, there is no order of any armed police. But the Siristadar does on its own. How? How is it possible?
Lord, I'll produce what action has been taken against him. Lordship will decide on proportionality.
No. But however, you see this. Now the district, he passes an order to that effect. Immediately on 10-8, kindly see, seen the petition on the file by the RIA for recalling of the writ as on so and so, perused and so, call for a report from the Nazir, and immediately he writes a letter out there. If he has passed that order to that area, it was also the duty of that particular courtmaster. What do you call that out there in the trial courts? There, bench assistant. The bench assistant's duty is also there to fix this, to give a date on the next date which is fixed in the other matter. He has the records. That book is with him. You have the cause list. These are not being done. Now you are pinpointing this particular person on this alone. Yes, Nazir is fully responsible. Equally, this particular person who is the PW2, and no action has been taken. How did the police help have happened? If anybody puts a question, how did the police help happen without the order passed under Order 21 Rule 35? It is impossible. This is a very serious thing. Mr. Das, why I'm saying, I'm telling you the reason why. I'm making it official in the open court. We are having a lot of problems as of now, which we are taking up on the administrative side with the conduct of the Nazirs. Matters where there are nobody out there in the other places. These are ex parte decrees. Nobody, the other side is not bothered. The Nazir does not move an inch. This is the problem which we are facing as on today. It is a very strict action has to be taken, and it is in respect to this very court. I'm saying it. This very Munsif court, where we are having a problem.
Otherwise also it is very difficult to shift the Nazir Milo. It's really very difficult.
So therefore, And it cannot be gone into, and I am surprised how the police help has gone. That is why I was
On the
looking.
first day itself.
Yeah. And why on earth the court did not say that judgment and decree? You say the decree in so and so state. What is this? Why don't you mention about the date? Whether how will this person know? Kindly see this order at page 79. The execution of the ex parte decree in so and so. Couldn't they have passed the date? Page 79.
Correct. Lordship is correct. There is no doubt about it that there were flaws on the part of the officer also not putting the date. But we are here, we are concerned.
Only because of that, putting a blame upon him. Yes, Nazim may be responsible, but putting a blame upon him is not conceivable.
Because the simple facts is allegation is that you were aware.
No, it is not that
He could
simple.
not
It
prove
he could not have been aware of unless you put the date. Why the court did not put the date of the judgment?
Lord, he in his evidence said that I handled the file and I knew about it from the date of an order from the date of within the date of execution. So that becomes part of the evidence, my lord.
That we will look into it. Well,
I'll
this is
also-
evidence.
my lord,
as
I'll
to-
also flag mark the evidence, my lord. Today it is not marked. I'll just flag mark to assist you, lord.
What is his name?
Sanai Mia,
DW7.
DW7, my lord.
After 2-3 days from so and so, but before 10 a.m., I've gone through the case record of so and found that there is no stay. Obviously, he categorically mentions that it came to the notice of it about Miss
No,
Case
he says
on 10/11.
and found that there was a stay order.
Yes.
But there is no mention of any title execute case number execution case number. It's the same
What
stay
is
order.
stayed? When you are praying for stay of the execution case, the court should have passed that order.
My lord, this fact he never brought during the course of the inquiry.
Which have been
In the appeal,
taken by the Nazir, but very often Nazir used to take some time records from my possession for getting to the area. After preparation, in case there were writs were issued for execution of decree, Nazir used to take those case records. I did not tell her when, while he met me after coming out from the room of here, that a stay order was passed in here. After going through it is not a fact that I was aware about the stay order and concealing the same in collusion with. Okay. We will, I
And
think this is
my-
the case for allowing the petition, not even proportion. Chalo. Hearing remained inconclusive. The matter would be again taken up for disposal, again taken up on 21st of July, 23rd of July 2026 at 3 o'clock.
in the following week, my lord, 23rd already lordship has fixed so
On
many
30.
matters. 30, my lord.
On 30 at 3 o'clock.
Fine.
And my lordship, my senior was projecting with regard to his not submitting. In page number 86 of his reply, he has stated clearly of the workload upon him. And in the same proceeding at page
It's
number
okay.
19.
I'm not saying when he was
No, but-
overburdened then. After DP, it's not after.
Mr. Das likes to do whatever may be, but I'm not going to assign, go by all this.
Obliged.
This is a case to set. This case is good for setting at right these Nazirs by way of a judicial orders. What are the duties of the Nazis and what they are doing? Yes, madam.
Lordship, I'd like to mention item number
Much
22 and 23. With consent, and next 2 weeks I will be out of station, Lordship.
Have a date whenever
After
you.
2 weeks, Lordship. Obliged, Lordship.